So, distinguished delegates, ladies and gentlemen, and dear colleagues, a very warm good morning to all of you. Welcome back. Welcome to our second and final day on this global roundtable on public information, access to information, public awareness, public participation, and access to justice on GMO and LMO matters. I'm glad to see you all back, fresh and full of energy for the second day and for the remaining task which lies in front of us. I trust that you all have had a very nice and relaxing evening and a good night and a good sleep. So welcome back, and let's continue with our work, which started so nicely and so effectively yesterday during the day. Just to recap briefly, we had very nice and interesting and important opening remarks, introductory information. We adopted the agenda of our roundtable. We had a couple of interactive sessions with input presentations, panel presentations, and fortunately, a lot of feedback, questions, interaction, and discussion from your side. We covered ratification and implementation of the GMO, LMO related matters of both instruments. We covered access to information. We covered public awareness and education. And we started to cover public participation. And I'm glad that we already started with the public participation session. We could not completely finish our panel presentations and introductions, but we have some buffer and some time this morning to continue with that and also to allow for questions and discussions from your side. So having said that, I welcome again our panel members for this panel on public participation here with us at the podium. You have already taken your seats, which is very nice. Just to recap, we have Mrs. Jasna Pekusic from Bosnia-Herzegovina. She already gave her very interesting presentation yesterday evening. We have Mr. Alejandro Espinosa Calderon from Mexico, who will speak in a moment. And we have Mrs. Antje Lorch from the European Ecoforum NGO, who will also speak very soon on this panel. And then we will open up for questions and discussions. The remaining time of the day will be then dedicated to access to justice, which will be a very interesting session, including some training and a lot of interaction again. We, of course, will have coffee breaks and a lunch break. And in the course of the afternoon, continuing with the access to justice session, we will then hear the reports from our 4 rapporteurs. That's going to be very interesting. We will together have a session where we look into the future. We will together see what the future perspectives could be in our area of discussion here, the way forward. And there will be a closing of the roundtable with the chair summary from my side towards the end of this meeting. The plan is to finish at the latest by 6 p.m. this afternoon and tonight. So I hope this is all fine for you, and let us continue. Just reminding that for this session, we still have our rapporteur, our able rapporteur, Maria Ruohonen-Lerner from Finland, listening, taking notes, and summarizing. And we continue with a input presentation by Mexico. Alejandro Espinosa Calderon, Executive Secretary of the CBOGEM, which is the Intersecretarial Commission on Biosafety and Genetically Modified Organisms in Mexico, will give his 10 minutes input. Alejandro, you have the floor.
Thanks. Good morning. It is very pleasant for me to be here. I greet everyone with affection. I appreciate the invitation of the Convention of Biological Diversity to present the topic on behalf of Mexico. Public participation as a mechanism for access to justice. Please, the next. Next. Intersecretarial Biosafety Commission of Genetically Modified Organisms, CBOGEM, is the body in charge on established public biosafety policies in the Mexican state. The CBOGEM is made up of 6 ministers and by the National Council of Humanities, Sciences, and Technologies, CONACYT. The executive secretary of the CBOGEM serves as the national focal point of the Cartagena Protocol on Biosafety based on Articles 19 of Cartagena Protocol of Biosafety and 108 of the National Law on Biosafety of Genetically Modified Organisms. Mexican government signed Cartagena the protocol on 24/2000 and was ratified in 2002. Next, please. Legal framework. The law on biosafety of genetically modified organisms, 2005, is the basic regulatory framework for public biosafety policies, which can be aimed at creating capacities in this matter, as well as general law of humanity, science, technologies, and innovation, which aims to guarantee the exercise of the human right to science in accordance with the principles of universality, interdependence, indivisibility, and progressivity, so that everyone can enjoy the benefits of development of science and technological innovation, as well as human rights in general. The President decree, February 13, 2023, established some action to avoid the use of glyphosate and genetically modified corn in agriculture crops and direct consumption on transgenic grain. Law of the National Institute of Indigenous People fully recognize the human rights of indigenous and Afro-Mexican people and communities. Next, please. Next. The Mexican state has a regulatory system that allows for the prior condition for accessibility to biosafety information. General and federal law of transparency and access to public information, and general guidelines for the regulation of the accountability procedures of the federal public administration guide the action of state employees. National Transparency Platform, National GMO Biosafety Information System, and the National GMO Biosafety, whose objective is to organize, update, and disseminate biosafety information. All this information is available on open access website for general public. Next, please. GMO MBS organize, update, and disseminate biosafety information as application for GMO environmental release permits, GMO import authorization for human consumption, summaries of GMO risk assessment, as well relevant information of products derived from GMO. Final resolution regarding the importation or release into the environment of GMOs, and well as the modification of resolution derived from the review in accordance with the law. Socioeconomic effects of GMO, especially on indigenous and local communities. Report and relevant documents resulting from scientific, academic, technical, or any other type of work on safety. GMO Biosafety National Information Ecosystem is a web application that allows to consult the location of requests for the release of GMO into the environment that have been approved. Please, next. One more, please. In accordance with the public participation mechanisms designed by CBIOGEM, public participation takes place on some spaces in work session of consultation, council, and bodies. In territory for indigenous consultation, online, through the various national and linkage international biosafety forums, and the GMO Biosafety Social Linkage Platform in peasant and indigenous communities that are part of the Ethnobiological Gardens project, through community meetings, workshops on safeguarding biodiversity and participatory biosecurity. In research projects financed with public resource sources, knowledge as a tool against presence of transgenics in native corn in ejidos of the Usumacinta Canyon Flora and Fauna Protection Area, Tenosique, Tabasco. Through CBIOGEM social media. Next, please. Develop and execute effective mechanisms to ensure the participation of indigenous people and communities and the Afro-descendant population in decision-making regarding biosafety. Development of information materials in indigenous Mexican language. Promote information meeting in the territory. Increase participation and audience in online outreach events. Establish and develop a broad-based biosafety policy. Thanks a lot for your attention.
Thank you very much, Mexico. Thank you very much, Alejandro, for this very clear presentation, from which I think it has become very clear that you have a substantial and inclusive framework in place in Mexico, and in particular in the public participation area, you are taking care of involving indigenous peoples, local communities, and that you are also interested and also successful in ensuring that local languages can be taken into account, which I think is a very, very good effort. Thank you very much for that. Now, let us continue with the third panelist. I'm happy to give the floor to Mrs. Antje Lorch from the NGO European Eco Forum for your presentation. Please, Antje, you have the floor.
Thank you very much. I'm Antje Lorch. I'm a member of the NGO Eco-Europa, which is a small network that has been dealing with biodiversity, environmental issues, and human rights since the late 1970s. And we're part of the European Eco Forum. Next slide, please. So next slide. Just a short reminder, because this is a session on public participation. So who is the public? And that's not just the average person on the street. That is also farmers, beekeepers, food producers. It's scientists of a very wide variety of disciplines and it's people working in NGOs and other organizations who have been working on these issues for a long time. And as such, we are providing input also in risk assessment and monitoring. We can provide input in socioeconomic questions, as well as in capacity building. Next slide, please. So the key systematic challenges that we see when it comes to the approval of GMOs is that this is not like building a road or a nuclear power station. A decision for cultivation of a GMO is usually a decision that a specific type of GMO can be cultivated anywhere at any time in the future. So it means when we have these discussions, we don't know whether this field on the right or left will have GMO crops in there in 5 years or not. Next slide, please. So on the one hand, we have the scope of a discussion to allow cultivation that is very broad, and we have a broad range of effects that we need to take into account, versus an approach to have a centralized decision-making by the local authorities, or even in the case of the EU, by a supranational supranational authority based in the EFSA and in Brussels in the EU. So we have this contradiction of the very broad scope and the very centralized decision-making. Next slide, please. So I was asked to give some examples for cultivation for good practices on GMO approvals or decision-making. And well, when I looked at it, we simply don't have any commercial cultivation in our countries at the moment. That's coming from the Biosafety Clearinghouse, which is a really good resource for this. And actually the last approval procedure in the EU for cultivation, for release in the environment, has been more than a decade ago. Meanwhile, many Aarhus parties have by now developed rules on biosafety, GMOs, and more. Next slide, please. But in this time, like since the last approval was given, actually communications and form of public participation have changed a lot. 5 years ago, I think most people in the room wouldn't know what a Zoom call is. We wouldn't have thought of just taking our phone out to come into a building like this without having a printed label, a printed badge. So a lot has changed. So currently there's no current example simply due to the absence of cases on GMO decision-making, as was also highlighted in one of the background documents for this meeting. Next slide, please. When it comes to LMOs for food and feed, there have been import approvals given by the EU. Again, this is a centralized process by the EFSA and the EU Commission. So there isn't really much public participation besides written comments given to the EFSA. And given the way how the EU system works, decisions can also be taken against the will or the abstaining of parts of the EU member states. So even if we would have access or public participation in our national authorities, that still gets lost along the way by the time it reaches the decision-making on an EU level. Next slide, please. I briefly want to highlight labeling and cultivation registers, because even though this is actually more access to information, labeling of products as either containing GMOs or as GMO-free allows the public to take individual decisions after a GMO or an LMO has been approved for cultivation or import. This doesn't influence the actual decision that was taken initially, but it also sets the scene for further decisions on these topics. Similar to cultivation registers, that depending on the detail on how specific information is given where GMO crops are grown, it does allow farmers or beekeepers to avoid the direct contact with GMO cultivation. And again, it helps setting the scene for future decisions on this or other GMOs. Next slide, please. So positive trends. We have heard a lot already about the Biosafety Clearinghouse, which is publicly accessible information on GMOs and LMOs. What's particularly important to me is that parties have the obligation to add information on GMOs as an ongoing process. So it's not voluntary, it's that parties have to provide this and have to make sure that both other parties, but also the public in general, can access this. And in addition, I think the Secretariat has done a great job in also providing trainings, rosters of expert, background information, and capacity building there. So again, this is a very good tool to have. Next slide, please. But now come to the negative trends, and that is actually the attempt to simply exclude new type of GMOs from the approval and from other decision-making processes, from risk assessment and from labeling and registering. So all of the good things we have would just be getting lost if GMOs are declared not to be GMOs as such. In the CBD negotiations, we've come across that as synthetic biology, and in the EU and maybe other countries, we have come across this as mainly as a proposal of the EU Commission from a few months ago to deregulate many GMOs as so-called new genomic techniques, NGTs. Next slide, please. I'll go a little bit more into detail on this because it is currently playing out. There was a vote in the Council of Agricultural Ministers yesterday on this. So basically, on a very arbitrary decision, which is neither scientific nor safe, there's a proposal to say if there's only 20 changes of up to 20 nucleotides and some other criteria, then these crops can be, or these plants can be excluded from approval. They can be excluded from risk assessment, from monitoring, from labeling. This concerns both crops and wild plants. So this also includes grasses, trees, things like that. There's a very interesting study which also just got published last week as a preprint. So it is still going through the peer review process, but it's a study done by the European Federal Agency for Nature, the BFN. And they looked at a list of about 150 plants that are in the pipeline, a list that has been created by the Swiss Federal Office for Environment. So this is not NGO data we're talking about. This is the national authorities that we're looking at. They made a list of about 148 plants that are in the pipeline. I said for 48, we can't quite see how they would be made. So we have 100 left. Out of that, 15 would definitely still be GMOs. We have 85 left. Out of that, 80, that is 94%, would be considered NGT class 1. So if we look at this pipeline, we have at least 80 different plants, including wild plants and trees, that would go onto the market, released into the environment without approval, without risk assessment, without monitoring, without labeling, and therefore also without public participation. Next slide, please. So just to make this clear, if there's no decision-making, because there has been a general approval given, so if there's no decision-making, there's also no public participation. So with this EU proposal, we would also lose all public participation on this. And it's getting even worse if the whole decision to deregulate these GMOs are also made without public participation. There is no public participation in the decisions of the EU Council or of the EU Parliament. Next slide, please. So the way forward is very straightforward, no deregulation, but better decision-making processes, including risk assessment. Thank you very much.
Thank you very much, Antje. Thank you very much, European Ecoforum, for this presentation, I think in which you made clear how important labeling and cultivation registers are, for example, to ensure information as a prerequisite for participation. I think you also highlighted the importance of the Biosafety Clearinghouse, also as a legal obligation. And thank you for elaborating on the challenge which the new genomic techniques bring, and the fact that there is a link between decision-making and legal requirement for a decision-making process and public participation. And of course, any deregulation activities may interfere with this link. Thank you for elaborating on these points. Now, and I would like to thank all three panelists for their presentations, Bosnia-Herzegovina already yesterday afternoon, and now Mexico and the European Ecoforum. I think with your inputs, you have covered very nicely and broadly your experiences in this field, public participation. And we are now in a good position to have even a little more time than in the other sessions for any questions. First of all, if there are any questions to the presenters, but also if you have any reflections or discussion points which you would like to bring. For example, from your side, important aspects of public participation, what forms of public participation you regard as relevant and important, how you think how and when public participation should take place. Maybe you can also elaborate on the selection of stakeholders and also on the question of how comments from the public in a public participation process are then incorporated in the decision-making process, if this is sufficient or insufficient. So any reflections on these points, again, I would like to throw out as guiding questions to you. And I see already two raised flags. First of all, European Eco Forum as well, Eco Forum, Ilya Trombitsky, and then followed by Kenya, please.
Strange, but I have a question to European Eco Forum. Two questions. First of all, because I'm not from the EU until now, and I want to ask if the feedback from the European Commission is a normal thing in the EU when comments are coming from the public and in relation to biosafety issues. First of all, and second issue is if this new intention of the EU to deregulate the GMO, new kind of GMO could be a subject of the communication to the compliance committee, because the convention itself does not do any differences between different types of GMOs. Thank you. In your view, of course.
Thank you, Ilya. We will come back to it. And the next question or reflection is from Kenya, please.
Thank you, Chair. I'd like to ask Angie from the EU Eco Forum. You made reference to beekeepers specifically and farmers. How would a GM crop, for example, affect beekeeping, even theoretically speaking, as an example? Two, you have presented on the labeling of NGT products, the new genetic technologies, and riding from your colleague who has just asked the other question. What would be the basis of labeling? I mean, what would be the marker? If, for example, we have two products, one arising from new genetic technologies, breeding technologies, and the other conventional, what would differentiate the two? What would be the marker? In classical GMOs, we look for example, S35 as a promoter, or TNOS as a terminator, as markers that can tell us this is arising from GM technology, this is not arising from GM technology. In the context of new breeding technologies, how will that marker be? What will be the distinctive character between the two? Thank you, Chair.
Thank you, Kenya. Are there any further questions, reflections at this stage? Indonesia, please.
Thank you for all the presenter for the clear presentation. My question for Mexico. First, you said at the GMO and this provide information regarding socioeconomic effect of GMO, especially on IPLC. Is this a scientific opinion, or you conduct a survey to the IPLC? And is this report of socioeconomic effect for each product that submit to the government, or as a general socioeconomic effect of GMO as a general? And second, regarding the public participation, you also mentioned that you done in territory for indigenous consultation. Is this always conduct for each proposal that submit for approval, or as a generally action? Thank you.
Thank you very much, Indonesia. The European Commission, please.
I would like to just say a few words about this general remark that the moment the Commission is proposing something new, some things will be closed for any sort of public participation. So I'm not an expert on GMOs. I work on access to justice and information issues on ARUS. But what I can tell you from the better regulation rules that the European Union has in place, whenever the Commission is making a legislative proposal, that proposal is out there for public consultation actually, and all stakeholders have the possibility and the right to comment on the proposal made. So actually there is no legislative initiative ever that is passing and circumvening the possibility for the wider public to express their views and opinions on it. And this is the same for this new proposal of the Commission as well. So the legislative proposal itself was submitted to public consultation before, I'm pretty sure of that, because those are the rule in place for every new legislative proposals that is tabled by the Commission as the initiator of legislation in the EU. Thank you.
Thank you, European Commission, for this important clarification. Now, if there are no further requests for the floor, questions or reflections at this stage, let me hand back to the podium and of course also to other colleagues here in the room. But maybe let's look first at our colleagues at the podium. There were some questions raised to Mexico. There were some questions and reflections concerning the current discussion in the EU on the new genomic technique legislation. There was a particular question on beekeepers and farmers, how they would be affected. Also on labeling, what would be the marker or the criteria for distinguishing between NGTs and conventional products. So I think I covered most of the points raised, and who would like to come in? Antje, you start off, please.
Thank you. Especially thank you for the EU for the clarification on the public participation process there. I know that my colleagues in Brussels are working hard on trying to get views of NGOs heard, of civil society heard on this, but it is still a very restricted process, especially when it comes to something that has an effect on farmers, on the public in 27 member states, in 27 different languages, that are not all or can't all be handled by just sending in written comments on a legal process. The question about from Kenya about how farmers and beekeepers can be affected. Well, farmers, for example, if there is contamination, if there's contamination of pollen from one field to the other, and you have a contaminated seeds for the next season, beekeepers, especially when bees, for Europe, that's especially when it comes to rapeseed or maize. Bees pollinate rapeseed, so they fly to the flowers, they pick up pollen there that goes into the honey. And actually the same is true also for maize. Even so they don't pollinate maize, bees have been observed quite often to actually go and collect pollen as feed for their young larvae. And unless we know unless there has been a risk assessment done and we know that there isn't any negative effects on the bees, we still have to have a precautionary approach to check that, so that the bees aren't harmed by the toxins that are there for the target organisms. For the basis for labeling, in the EU, we have a process-based labeling. So we don't need to see a marker in the individual product afterwards. So it's not a question on, can you find the marker or not to label it, but in the process, has there been GMO involved? So that solves that question. And on Ilya's question, and as you know, the European Eco Forum is a network of NGOs in the AOS countries, which is why we sometimes need to talk to each other, even from the plenary. When an approval process is given, then it's usually an application is done in one country, that country passes when it deems it appropriate, passes it on to the EU, where then the European Food and Safety Authority, the EFSA, is making an assessment and a report about it. And then the EU Commission can propose to approve of this GMO or not. And therefore, the main point where you can input as a public is when it is at the level of the EFSA, when you can then also get all the information that the EFSA has with some reduction, and then comment on those written papers. For the compliance committee, that's an interesting approach. However, I think we can't do that before this has passed. I'm not sure the compliance committee wants to look into future cases. Thank you.
Thank you, Antje. Maybe Mexico, would you like to reflect on the questions raised by Indonesia, please?
Indonesia, thanks a lot for us the question. In Mexico, CBOGEM support the strategies, political strategies based in opinion of the Special Consultative Scientist Group. The effects of economic are student so much, and we have elements to have the better political decision and strategies. And the second part of the question, please. Indonesia.
If I understood correctly, the second part was referring, but please correct me, Indonesia, the survey to the indigenous peoples and local communities. And there was also the question if that would be based on each product application, or if you would have a more general.
It's a general regulation.
Okay, Indonesia says thank you. So you obviously covered her question. Thank you so much. Any further reflections from panelists on the podium? Further reflections from colleagues in the room on this first set of questions? No? Then let me briefly check if there are further comments and questions which you have. We would have a short time available for that purpose.
Maybe
Mexico.
Maybe says that all information in Mexico is available for in general for the public on the web.
Yeah, I forgot in my presentation that I actually wanted to thank Bosnia-Herzegovina for the presentation, because I think the approach you have shown us actually shows what is possible in public participation. Thank you very much on that.
Thank you. And Bosnia, please. Bosnia-Herzegovina.
Thank you. But even that, if we have a very good tool, and it is obligatory tool for all institutions on government, and even if we obligatory do we put the official website, we are not completely satisfied with the public participation in that it is small progress, but it's still progress. And I hope so, that because our law on GMO is quite well old, and the next year it's going to be a real test for us, because we are already preparing the new one. So we will see, is this really good approach to participate public? Thank you.
Thank you. Thank you, Bosnia-Herzegovina, also for your open words, but it is step-by-step progress we are trying to achieve. And even if you have first successful results and there is room for maneuvering and getting even better, that's a nice way of approaching the issues. Now, dear colleagues, I think this session, and thank you very much for your presentations and for the questions and discussion, has clarified that access to information, of course, is an important prerequisite for public participation. The experiences which you have shared show that there are different ways of approaching. There are very convincing approaches, as we have heard from Bosnia-Herzegovina, on an e-consultation tool, a user-friendly website, which is indeed an important step to involve even more public participation than you have achieved so far. And that could be a good practice example also for others. We have also seen that there is quite a challenge with new genomic techniques and with other technological progresses or developments with respect to being covered by legislation or not, and with the following issues concerning public information and public participation. Labeling we have addressed, and also the question if it only needs to be based on analytical detection, and we have recognized that there are other ways of ensuring appropriate labeling, and of course examples such as organic farming or environmentally friendly labels, deforestation-free products also come to my mind when I think about this field. Now, colleagues, this was extremely rich and very important, and we are right in time to switch to our next session. And I would like to thank our panelists. You may again take your seats, and thanks for all your inputs. Thank you. They deserve an applause. Yes. Program of this round table. And we come to a very important session. As I've said before, all the sessions are important, but this one is going to be particularly interesting because the next couple of hours, including a lunch break, but still a couple of hours, will be dedicated to access to justice. It is our sixth session in this global roundtable, so we are progressing. I'm happy to announce that also for this session, we have a very experienced and able rapporteur, Mr. Faustino Gudin, who is a senior judge at the Criminal Court of Segovia and associate professor of the Alcalá University in Madrid in Spain. So we are very pleased that you are here and that you will carefully listen and summarize all the presentations and discussions. And also here we are looking forward then to your report towards the end of our meeting this afternoon. So thank you for your availability and for your willingness to do that. Now, the session on access to justice, including a training session, is indeed very important, because access to justice is rather a new topic for the global roundtables on GMOs, LMOs. In the previous roundtables, we have not really covered it and not covered it in the same level of detail as we are going to do it now. I'm also welcoming very much Mrs. Summer Kern, senior environmental lawyer, as facilitator of the training session. You can join us already at the podium. Yes, please do so. The training session will start after a round of presentations, and then I will hand over to you as facilitator. But we are very pleased that you are with us here today, and we are looking very much forward to your guidance in the training session later. I would also like to invite you as participants really to use this opportunity. It's a unique opportunity. Ask questions in the course of the next couple of hours to the presenters and to the facilitator, and really benefit as much as you can from their experience and their presence at this meeting. We will again have two input presentations. We will kick off this session by two input presentations, which will give a kind of introduction to the provisions of access to justice in the Aarhus Convention and also in the Kunming Global Biodiversity Framework, is in particular the Target 22. Colleagues will go into more detail. So that is why I now invite Mrs. Marina Janusz. She has spoken before, you already know her. of the Secretariat to the Aarhus Convention to make your introductory presentation on access to justice. Please, Marina, you have the floor.
Thank you very much, Mr. Chair. Good morning, dear colleagues. This time we turn to the third pillar of the Convention, access to justice. And this pillar is indispensable actually for the two other pillars on access to information and public participation and decision-making that we have already discussed. And also access to justice mechanism is important to enforce biosafety framework in all three areas. So it would cover deliberate release of GMOs into the environment, placing on the market, and contained use of GMOs. So on the next slide, I would like to highlight that the Aarhus Convention provisions on access to justice aim to protect environmental rights and the legitimate interests of the public, and also enforce environmental laws. And the main focus of the convention on two elements. It's effectiveness of access to justice mechanism, which would include independence and impartiality, timeliness, effective remedies, and also its accessibility to the public, because the mechanism will not be used if the public does not have sufficient knowledge or access to sufficient knowledge, have prohibitive costs, have long distances, or have fear to request access to justice. And these both elements are critical for GMO cases because these cases are complex. They require access to scientific knowledge and access to independent expert opinions and environmental expertise. And now I would like to dive on the next slide in the obligations related to the Article 9 of the Aarhus Convention on Access to Justice. But before that, I would stop on the definitions that we have already discussed. It's regarding the public and the public concerned. And these definitions are also important for access to justice pillars. So the members of the public are not limited only to natural and legal persons, but also to associations, organizations, and groups. And also important to highlight that NGOs promoting environmental protection and meeting any requirements under national law shall be deemed to have an interest in decision-making, but also in access to justice matters. In order to enable public to seek justice, there are several important obligations that public authorities would need to implement. So they would need to assist and guide members of the public how they can seek justice. They should provide appropriate recognition and support of environmental NGOs. They should provide information on access to review procedures and establish a system mechanism, not only for individuals, but also for environmental NGOs, and also take into account the special needs of the groups in vulnerable situations, like children, youth, indigenous people, and persons with disability. Importantly, public authorities would need to take measures against any penalization, persecution, and harassment to protect environmental defenders, because otherwise these rights would not be exercised and all the system would not work. And you know that the parties to the Aarhus Convention established rapid response mechanism to protect environmental defenders, and the work in this area is evolving. And of course, important that no discrimination is kind of the principle of no discrimination is exercised also in law, but also in practice. For example, e-justice tools that could be available should not discriminate on the basis of citizenship, nationality, and so on. On the next slide, I would like to mention the first category of cases that is protected by Article 9 of the Aarhus Convention. And it protects the first pillar of the convention related to access to information. So the review under this convention's provisions can be requested by any person that requested information related to genetically modified organism. So what can be reviewed? It's any decision, act, or omission of public authorities. So, and this provision would cover silence of administration to respond to information request, or decision on refusal to provide information on certain grounds. And implicitly, the review would cover procedural and substantive legality. So modalities would include the review before court of law or another independent impartial body. In some countries, information tribunals or environmental tribunals have been established. But we need to keep in mind that the most persistent challenge in this area is lengthy procedures, especially when information is needed within time-bound decision-making process. And one of the solutions that the convention suggests is to establish expeditious procedure. And expeditious procedure would include reconsideration by public authority or review by other body than a court of law. And it could be, for example, information commissioner that could provide very quick and inexpensive mechanism to consider these cases effectively. Decision should be binding on public authority holding information, and reasons should be stated in writing. And is a good practice, the court or other independent review body should be able to disclose information to avoid ping pong between the review body and public administration in refusing information on other grounds in provision this information. On the next slide, I would like to highlight the second category of cases which are relevant to decision-making procedure. So here the review can be initiated by members of the public concerned, and we know already the definition, having a sufficient interest on maintaining impairment of a right. And what constitutes sufficient interest or impairment of a right shall be determined in accordance with the requirements of national law. So it could include some interest related to the residents, to exercising certain activities, but importantly that objective of the implementation of this article is to provide a wide access to justice within the scope of the convention. Again, NGOs promoting environmental protection shall be deemed to have an interest in this decision-making, in access to justice. So what can be reviewed? It's a decision, act, or omission subject to Article 6, which is related to decision-making on individual activities, or other relevant provisions of the convention. So it would cover permits or authorization on placing of GMOs on the market or release into the environment. It can also cover plans, programs, and other documents in accordance with the national legislation. And explicitly, the scope of review covered substantive and procedural legality. We've heard already that a decision-making procedure on GMOs matters are usually multi-stage. So it includes scientific assessments, it includes different opinions of public authorities. So it's important to clearly set in the legislation the reviewability of the decision, act, or omission at each stage of the process. And the review also should examine any defects in the preparatory acts, assessments of the proposals of other authorities that can affect the validity of the final decision. So the modalities for the review include the court of law or another independent or impartial body established by law. Again, we can say about environmental tribunals. Preliminary administrative review is also possible in accordance with this provision of the convention. But what's important to underline is that the applicant can challenge procedural and substantive legality of GMO-related administrative decision in the administrative review. Then he can obtain the decision on the errors in the authorization and request than the court to control the decision of administrative review body. And as a good practice, judicial control of administrative review decision should take into account arguments regarding the substantive unlawfulness of basic or challenge permit or another authorization. And on the next slide, the third category of cases relates to cases that violates biosafety laws. So this provision can be also effective to support public monitoring on GMO-related matters. So the review can be initiated by members of the public. Standing criteria are optional, but should not prohibit all or almost all members of the public, including NGO, to access justice. So what can be reviewed is any act or omission by public authority or private person that violates laws relating to GMOs on biosafety. And it could cover also permits and plans and programs, but it also can cover acts and omissions relating to environmental damage. And the scope would also include substantive and procedural legality. The review can be carried out in the form of administrative review or judicial review. And this article covers also criminal or administrative investigations. And on the next slide, I will just summarize basically the requirements to these provisions. So who can ask for the review in accordance with the convention? So the convention encourages a broad standing, including for NGOs, to bring a challenge. What can be reviewed? It's the decisions, acts, and omissions. And the review would cover substantive and procedural legality. The review should be carried out usually by a court of law or another impartial and independent review bodies. And administrative review procedures are possible, but it's non-exclusive. And procedures must be fair, equitable, timely, and non-prohibitively expensive. And of course, the convention requires to provide adequate and effective remedies, including injunctive relief. So the case should not be only won on paper, but also make a change on the ground. And decisions shall be binding in writing and publicly accessible. So on the next slide, I would just highlight several challenges that were identified in 2021 synthesis report on the implementation of the Aarhus Convention. It's a lack of awareness of legal professionals and the public, lack of standing for environmental NGOs or tightening criteria for standing in several cases, financial barriers, lack of assistance mechanism, lengthy court proceedings, inadequate remedies, and enforcement of final decisions. There are some positive strengths on the next slide that include increased admissibility of public interest litigation cases, increased substantive review by courts, reduction of some financial barriers, increased specialization of judiciary, and measures taken to raise awareness in environmental law and access to justice. And finally, on the next slide, there are certain measures that were identified by the meeting of the parties and the synthesis report. So the first is to update the legislation on access to justice and ensure its compliance with and ensure compliance of the practice with the requirements of the Aarhus Convention, support trend in increasing admissibility of public interest litigation and collective redress, continue strengthening specialization of judiciary and other legal professionals in environmental law, improve capacities of courts in using knowledge about environmental risks and access to independent environmental expertise, continue to raise awareness of the public and legal professionals, and ensure that environmental law curriculum adopted in law faculties, judicial training institutions, and other educational institutions, continue developing e-justice initiatives and use of modern digital tools, ensure assistance mechanism and the availability not only to individuals but also to environmental NGOs, promote multi-stakeholder national dialogue to remove existing barriers, adopt measures to discourage strategic lawsuits against public participation, and promote international cooperation in the area of access to justice to ensure a level playing field between the countries. Thank you for your attention.
Thank you very much, Marina. This has been thanks for outlining to us the current stage with respect to access to justice within the Aarhus Convention, and specifically referring to the 2021 synthesis report, which of course provides some very relevant insights. Now we move on, and I kindly invite Mrs. Inonge Mene from the Secretariat of the Cartagena Protocol to make your introductory presentation. Secretariat of the Cartagena Protocol, CBD, of course. And we are looking forward to your presentation, which will address the Global Biodiversity Framework and respective provisions. Please.
Thank you, Chair, and good morning. So my presentation is on access to justice under the Kunming-Montreal Global Biodiversity Framework. So in brief, my presentation is going to be, I'll start with an introduction, and then I'll talk about access to justice under the GBF. I'll talk about implementation. I'll talk about other roles in the implementation, and then I'll offer a conclusion. Next slide. So maybe I can just give a brief introduction to the GBF. So the GBF was adopted by the parties to the Convention on Biological Diversity in December 2022. So the GBF seeks to halt and reverse biodiversity loss. So this means conserving 30% of the world's land and 30% of the world's oceans by 2030. So the GBF has a vision and a mission. The vision is a world of living in harmony with nature, where by 2050, biodiversity is valued, conserved, and restored and wisely used. The mission is for the period up to 2030 to take urgent action to halt and reverse biodiversity loss. So it's mainly about biodiversity loss and how it can be addressed. So that's a general introduction to the vision and mission. So the GBF has, next slide, please. The GBF has 4 long-term goals for 2050 related to the 2050 vision, which I just mentioned, and 23 global targets for urgent action over the decade to 2030. So for those targets, the actions are supposed to be taken on a whole society level. So they're supposed to be taken by governments, subnational and local authorities, and with the involvement of society. So it is expected that these targets will contribute to the achievement of the 3 objectives of the Convention on Biological Diversity. So these objectives are conservation of biodiversity, sustainable use of the components of biodiversity, and the fair and equitable sharing of the benefits arising from the use of genetic resources. So on the next slide, I'll just refer briefly to target 17. So I think it was mentioned in some presentations that were given yesterday by the CBT. So mainly it's a target that refers to biosafety, and then it also refers to living modified organisms. So the main purpose was just to show that the GBF is a very comprehensive document, which also involves issues of biosafety. So I won't dwell too much on the target. It's one of the targets. On the next slide, I will now delve into access to justice itself. So the target that refers to access to justice is target 22 of the GBF. So I think for me to discuss it, I'm going to read it. It's there on the screen, but I think maybe let me go word for word so that I can explain the elements later. So target 22 reads as follows: ensure the full, equitable, inclusive, effective, and gender-responsive representation and participation in decision-making and access to justice and information related to biodiversity by indigenous peoples and local communities, respecting their cultures and their rights over lands, territories, resources, and traditional knowledge, as well as by women and girls, children and youth, and persons with disabilities, and ensure the full protection of environmental human rights defenders. So from what I have read, there are clearly about 5 main elements in Target 22. So on the next slide, I have listed what those 5 elements are, but I think what is of interest to us for this presentation is the 3rd element, which says providing access to justice and information related to biodiversity to indigenous peoples and local communities, women and girls, children and youth, and persons with disabilities. So on the next slide, I just want to add that environmental human rights defenders are also included in this access to justice, as the target refers to their protection. So that's something that I wanted to spell out. So in terms of access to justice, I think our general understanding, we can agree, is that it enables people to exercise their rights, challenge discrimination, and hold decision makers accountable. So it follows that access to justice and human rights are interconnected. Most importantly, for the GBF, it's supposed to have implementation is supposed to have a human rights-based approach. So the GBF acknowledges the human rights to a clean, healthy, and sustainable environment in line with various UN resolutions and UN Human Rights Council resolutions. So on the next slide, maybe briefly I can say that because it's really related, Target 22 and human rights are related. So a healthy environment is a necessary precondition for the effective enjoyment of many human rights, rights to life, rights to food, and then the human rights harms associated with biodiversity loss disproportionately fall on those who depend directly on them and on nature. And those are usually in vulnerable situations. So access to justice is closely linked to the human rights challenges faced by those people in the vulnerable groups identified in Target 22. So these, I'll repeat, are IPLCs, women and girls, children and youth, persons with disabilities, and environmental human rights defenders. So of course, environmental human rights defenders play an essential role in safeguarding the environment and human rights. A human rights-based approach to biodiversity planning aims to address inequality and discrimination. So on the next slide, I'll briefly look at implementation. So as I've mentioned, the GBF is a comprehensive document that contains goals and targets. So one of those targets is Target 22, and Target 22 is included in the implementation mechanism. And maybe just to say that this is a very new document for CBD, access to justice. It was adopted in December, and it's the first time that access to justice has been addressed directly in the legal instruments of the CBD. So in terms of implementation, it is at a very early stage. I can only discuss what the document says. We do not really have practical implementation yet because it's just been since December, yeah. So in terms of implementation, this is how the GBF is supposed to be addressed. So national biodiversity strategies and action plans, NBSAPs, are what are going to be used to implement the CBD at national level. And national reports are the main instrument for monitoring and reviewing the implementation of the CBD and the GBF. So when the Conference of the Parties adopted the GBF, they also adopted a multidimensional approach to planning, monitoring, reporting, and review. So of course, it comprises NBSAPs being revised and updated to align them with the GBF and its goals and targets, submission of national reports, including indicators in the GBF monitoring framework, and also review of progress on the implementation of the GBF based on national reports. So on the next slide, so the same GBF, the same COP decision 15.6 in its annex highlights the importance of these NBSAPs. So they are an umbrella process for national targets and actions relevant to the GBF and also relevant to target 22 in our case. So they are the main instrument for parties to communicate their contribution to the GBF and its targets. Enhanced access to justice here. So they involve all government sectors, stakeholders, IPLCs, women and youth across society to ensure that the concerns of different actors are addressed. So the annex also contains a detailed template for the submission of national targets as part of the NBSAPs towards the implementation of the GBF. On the next slide, I'll also, I think maybe briefly I can talk about the roles in terms of implementation, the specific roles. So they are identified in the GBF. So the first category is parties and other governments and all other relevant organizations. So these would provide financial and technical support for GBF implementation, especially for least developed countries and small island developing states. And then you have international, regional, sub-regional, or national organizations. So these would support countries in the updating and revision of NBSAPs and the preparation of national reports. You have donors, governments, and multilateral and bilateral agencies. So these would provide funds to support planning, monitoring, review, and reporting for the implementation of the GBF. And then, of course, we have the Secretariat, so the Executive Secretary, who would provide overall Secretariat support, coordination, conduct a strategic review and analysis of the programs of work of the Convention in the context of the GBF to facilitate its implementation. On the next slide, I'll offer a conclusion. So from what I have talked about briefly, I would say that the right to access to justice for IPLCs, women and girls, children and youth, persons with disabilities, and environmental human rights defenders in Target 22, coupled with the GBF human rights-based approach, is a fundamental step towards ensuring that these vulnerable groups can effectively exercise their rights, challenge discrimination, or hold decision makers accountable in biodiversity-related matters. So I think I already mentioned that this would be an effort at all levels of government and society, which is envisaged by Target 22 itself. And also there would need to be capacity building and the necessary resources to implement these targets. So of course, the CBD Secretariat is looking forward to collaborate with the processes under the Arles Convention and also similar multilateral processes and to assist governments and communities understand and implement the access to justice element of Target 22. Thank you so much. This is my presentation.
Thank you so much, Inonge, for a very clear presentation. I must say, having participated myself in COP15, but having covered quite different subjects, I appreciate a lot now having such a clear explanation from your side what parties have agreed upon in Target 22 and what the implications are. So that's extremely helpful in general, but in particular for the purpose of our roundtable here. So, dear colleagues, we have heard now the two input presentations by the representatives of the two secretariats. As always, let me briefly check if there are any questions to our colleagues before we move to further panel presentations as a basis for discussion. Republic of Moldova, Angela, please.
Thank you, Mr. Chair. I would like to thank two representatives of two conventions, Aarhus Convention and Cartagena Protocol CBD Convention. It is a very comprehensive information related to access to the justice in relation of environmental issues. And it is very important to address these issues in the context of the Kunming-Montreal Global Biodiversity Framework. At the same time, however, I would see some future needs to develop maybe a roadmap to provide a mechanism of conversion of these two international agreements and specifically to the living modified organisms, as the access to justice is the mechanism that have been already developed is mostly to the general questions for the environmental protection or biodiversity, and not specifically to the living modified organisms. This issue is related also with the NBSAPs that now countries are in the process of updating and developing for the new, in accordance with the new global biodiversity framework. And also it is important that national legislation would provide a very clear mechanism for public access to information and access to justice in relation to living modified organisms. I would see that we probably would need to develop some kind of roadmap for next actions and next activities to develop these mechanisms. And also, what I understand, it is very important, and Marina mentioned in her presentation, it is very important to find and develop a financial mechanism to support this activity. So the Global Biodiversity Framework also addresses the needs to develop a financial mechanism specifically for biodiversity conservation. And I consider that this would be also need a very critical need to support financially some capacity buildings, some development, some mechanism at the international and also national level, regional level, and national level. And to mention that the Cartagena Protocol is looking for regulation of transboundary movements of living modified organisms that would need to have also in place a very clear legal mechanism for justice and access to justice at the international or regional level. Thank you.
Thank you very much. Thank you very much. Moldova, thank you, Angela. Your point is already quite a very important reflection and discussion item then for later. I don't know if our two colleagues, Marina or Inonge, would like to react on the point raised by Moldova, but then we have to move on because we are running a little bit short out of time. You have an immediate point to this one? Yes, please. Please, could you use your microphone?
Pardon. Can you hear me? Yeah? No. I want to. So the first question is to Marina. It's regarding the question about the court disclosure information. I think it's absolutely interesting, but I find out two obstacles. The first one is the legal framework, because the judges, courts, and tribunals need a legal framework in order to get it. And the second is someone who pointed out this information who is hidden, because I think it's important too. Regarding to the Secretary Cartagena Protocol, I think also that the nitty-gritty of the question is the target 22 related to the articles 17, the targets 17 and AD. I am absolutely convinced that the access to justice is related to human rights. They are interconnected, but the problem is, as far as I know, what type of mechanism are you thinking about to get it? That's all. Thank you very much.
Thank you for your questions, Faustino. And then a final brief question by the General Prosecutor, Kyrgyzstan, please. Microphone.
Thank you, dear panelists. I would like to address my question to Mrs. Janusz. Our judiciaries are facing the problems when they are dealing with the injunctive relief. So I would like to raise the problem of the compensation, because sometimes when we're dealing with the environmental litigation, the eco activists cannot compensate the damage, and that is the reason when they are facing the problem of injunctive relief. So I would like to know your opinion about this issue. Thank you.
Thank you, and thanks to all the questions. Now let's briefly turn to Marina and Inonge. Marina, maybe you start.
Thank you very much for the excellent questions and suggestions. I would completely support what our colleague from the Republic of Moldova mentioned, and especially thank her for mentioning the importance of cooperation within the transboundary cases, because it will bring many challenges regarding the mutual recognition of the documents of expertise and some other issues, and we would need to continue working on this. So it would be actually indeed a systemic area of work. And also, thanks a lot for highlighting the importance of effectiveness of access to justice procedures in information cases. So as you know, we have carried out a study on the current practices in this area, and we have noticed these processes. Yes, it would require the change of legislation to empower the courts to have access to disputed documents and have the possibility to disclose the disputed documents. And also, I would like to mention a good practice from Germany, where actually the documents can even be disclosed as injunctive relief. So if it's a time bound, there are challenges because the convention links to Article 4, the access to justice and information cases, but it's really very important matter when it comes to public participation. And yes, and the same comes to the question on injunctive relief. So I think that the secure way to go there is to update the legislation and also to give the court flexibility regarding the application of criteria. And it's done in several countries here. I can mention, I think, example of Norway, when there is a possibility actually of non-applying the securities for during the injunctive relief. And I think you can also talk to our colleague Faustino, because there is a good Spanish case actually, I think in Canaries, where the securities were not applied.
Thank you. Inonge?
Thank you very much, Chair. And also, maybe I'd like to start by thanking Ms. Lausanne from Moldova as well. I think she mentioned a very important point about the synergies between the two conventions. And just to mention that there's a specific provision in the GBF that talks about those synergies, and it's very important, and how we can find a way forward on that, because that is something that is crucial to the implementation of the GBF. So in terms of the question, I think the question was about how access to justice is going to be implemented, if I'm not mistaken. Yes. So as I mentioned, what Target 22 says is that access to justice is for biodiversity related cases. So think of any biodiversity related cases. So the target is part of the GBF as a whole, access to justice. So what it means is that will go according to the implementation that is for the GBF itself as a whole. And as I mentioned, implementation is supposed to be through NBSAPs. So what is expected is that parties are going to include how they are going to implement it at the national level, because that's where it starts, and it will be included in their NBSAPs, and the necessary reports are going to be submitted on that. So it is the parties that are going to do that through their NBSAPs. Thank you.
Thank you very much, Marina and Inonge, for your very clear answers. And we now move on to the panel and to two further panel presentations. If I may ask Mrs. Laura Gornicio from the European Commission, Deputy Head of Unit of DG Environment, E4, Environmental Rule of Law and Governance, in the Directorate General for the Environment of the European Commission. So Laura, pleased to have you with us here, and you are joining the podium, which is very good. And then we will have another input presentation by Mrs. Andrea Nakova. She is already on the podium, which is very good, representing the European Eco Forum. So two further inputs. We start with Laura Guarnicio from the European Commission. Please, you have the floor for your 10 minutes.
Thank you very much. I have to say sorry for my voice, but on Friday I didn't have one at all. Now I have this one. I'll try also to be shorter than 10 minutes so that we can catch up a bit on time. My presentation is actually about a case which is a good example of how access to justice works in the context we are discussing those days. And it comes from what we called in the EU jargon a preliminary ruling, meaning a national court is submitting questions to the European Court of Justice, wanting to have clarifications so that they can, after that, implement EU legislation that stems from the EU. So next slide, please. You had a very comprehensive explanation about how access to justice is actually regulated in the Aarhus Convention, and this is a very, very basic overview of what are the provisions that are talking about access to justice in the convention, and for the EU in particular, what this means, because we have an implementation that happens of the convention at EU level in a regulation, which is in our case something that is directly applicable. And then we have, of course, also transposition measures in the member states, because we still have to keep in mind that the EU is party to the convention, the member states are parties to the convention, so everybody's bound by the rules of the convention at those two different levels. Next slide, please. The case at hand, as I said, it was a preliminary ruling, means a national court, in this case a court from Italy, has questions where they are not sure how to interpret or apply European law. And they submit those questions to the European Court of Justice. And with the interpretation that is provided by the court, they are then able to apply European law in that member state. This is important maybe to explain from the beginning, because de facto in a case like this, in a preliminary ruling, it's only the interpretation that the European Court of Justice is going to provide, and it's still going to be the court in the member state that will apply the law. What you will see also at the end as the outcome of the reply given by the European Court of Justice does not mean that the case, so to say, was concluded by the European Court of Justice. The European Court of Justice just explained how different provisions, and you will see there are at least 3 different instruments concerned, will need to be interpreted and applied. What happened in the case? A region in Italy adopted a law in 2011 that just prohibited the cultivation of genetically modified maize. There was a farmer in that region that was, of course, that actually cultivated a variety of genetically modified maize known as MON 810, that was then concerned because of this decision, and not only concerned, but also fined. So he was He was fined first a fine of 10,000 euros that he contested. That was after that reduced to 5,000 euros. And this was due to the fact that by cultivating the genetically modified maize, he was actually breaching this regional law that was prohibiting this cultivation. So the farmer took his case to the court. So first he contested the fine. The fine was after that reduced but not discharged, and the case ended in front of the district court of Pordenone. And this is the court that had those two questions they wanted to refer to the European Court of Justice. Next slide, please. So the first question is so long that I will try to read it slowly to make sure that I still understand what the question is about. So we have this ban, which was imposed by the regional law of this region in Italy. And the court, the Italian court, wanted to know if this ban is actually in line with what a directive is another way of ruling in the EU, that actually allows in certain circumstances the release into the environment of genetically modified organisms. So if this ban is in line with this directive that does not prohibit it per se, such a release, in conjunction with another regulation which is applied when it comes to genetically modified food and feed, and has a lot to do with procedures that have to be respected, authorizations that have to be gathered and all that. And in addition, another instrument, which is a commission recommendation. This is not a legally binding instrument, but nevertheless is used to help interpretation and maybe explain provisions that otherwise might not be clear enough. So this recommendation that deals with the guidelines of how national authorities should develop coexistent measures so that it can be secured that there is no unintended presence of GMOs in conventional organic crops. So basically the question was, is this ban, which this province decided to issue, in line with those different other legal instruments that are all related to the GMO, their placement on the market, their conditions to be placed on the market and all that. A second question, even more philosophically, was if this ban could have an effect that is contrary to articles that come directly from the Treaty of the European Union, and that have something to do with actually free market and all that. So as I was saying some minutes ago, the court in Luxembourg, when it's presented to those questions, will only take a position on the interpretation and the way the instruments are connected or interplay, but we leave to the court, the initial one asking the question, to really assess the court at hand using the sort of guidance they are providing. Okay. What the court wanted, that next slide, please, exactly what the court said to this first question, which was, is this ban more or less okay or not in line of all the other rules that apply? The court is saying that, I will read it out and after that I could try to simplify it so that I'm not missing something. So this article 26A of the directive 2001/18, which is the one allowing release into the environment of genetically modified organism, must be interpreted as not precluding a national measure which, for the purpose of avoiding the unintended presence of GMOs in other products, prohibits the cultivation in the territory of a region of the member state of concerned MGOs that theoretically are authorized under Regulation 1829 from 2003, provided that this measure enables the attainment of the objective of ensuring that producers and consumers have the choice between products from genetically modified crops and products from organic or conventional crops, and that having regard to the particular characteristics of those crops in the territory, the measure is necessary and at the same time also proportionate. So you'd see in bold in the conclusion of the court, so to say, the anchors that are important when a regional court or any other court at the national level would need then to assess a similar situation. I think it's super, I mean, we have some sort of conclusions to slides further, but it's important to keep in mind what can be the scope of such a measure per se, and it's important that this is to ensure the producers and consumers have the choice between products from genetically modified crops and products from organic or conventional crops. So not all sorts of aim would justify such a measure. And of course, like any other measure that it's actually imposing restrictions or it's being limiting in itself, it's necessary, it always has to be regarded that the measure is necessary and also proportionate to the aim to be achieved. On the next slide, please. On the second question, which I was saying was a bit more the philosophical one, that's an easier answer because what the court is saying is that the moment there is legislation that is secondary to this very high level of what the treaties are actually giving as guidelines or measures, the moment this is legislated more in detail, it's not going to be measured anymore at that very high level of the Treaty of the European Union, but it will be measured against the particular legislation that is enacted, and it's regulating more in detail the measures at stake. That's why there is no need to look in particular if the measures are in line with the articles of the treaty itself. Next slide, please. So very short overview of what we think we understood from this judgment. And to be frank, I tried to find out what the Italian court actually decided at the end, but that ruling I couldn't find. So if someone in the room knows what they did with the interpretation of the court, I'm also curious to know. So you don't know either? Okay. So what one could understand from this is that even if, of course, in theory and in practice, placing on the market of a GMO is authorized because there is a regulation in this regard, it can still be prohibited or restricted by a member state in accordance with Article 26A of this Directive 2001/18. But it needs to be taken into account the aim of the preventive measure, and it has to be related to avoiding the unintended presence of GMOs in other products. It has to take into account the degree of admixture of genetically modified maize that would need to be achieved, the probability of admixture and the sources of risk and effectiveness of the methods of crop separation, and what I said already before, the principles of necessity and proportionality. The second point is, was saying before that as there is specific legislation in this regard, the measures taken have to be measured against this specific legislation and not necessarily at the level of the primary law, the union law. So I think those are, in short, the conclusions that we can draw, can take from this judgment. And with that, we can go to the next slide that says, thank you very much for your attention. Thank you for your questions.
Thank you very much, Laura, for this excellent presentation. Very interesting case. And I understand that during the training session, we may also come back to it and see how it has been concluded, if anyone in the room knows how the Italian courts have decided. Now, let us continue with the next presentation, and I would kindly like to give the floor to Mrs. Andrea Nakova from the European Ecoforum. Please, 10 minutes maximum. You have the floor.
Thank you, Chair. I'm part of Journalists for Human Rights, which is an NGO deeply committed to environmental conservation and sustainability and preserving human rights. And I'm honored to speak today in front of you and present the situation both in North Macedonia and in the region. So North Macedonia, as a signatory to the Cartagena Protocol on Biosafety and a committed party to the Convention on Biological Diversity and the Aarhus Convention, recognizes the significance of preserving our natural ecosystems while acknowledging the potential benefits of advancements in biotechnology, as well as the importance of access to public information and access to justice. However, there are still issues of concern that need to be taken into account, and today I will share both the key systematic challenges in the country, as well as some positive and negative trends in the region. So next slide, please. What will be the key systematic challenges? Having in mind that even though progress has been made in the country, North Macedonia still faces some challenges in terms of access to justice. First, we have the regulatory framework, which means that access to justice concerning GMOs is directly impacted by the adequacy and clarity of the regulatory framework. The situation obstructs access to justice as it complicates the process for affected individuals or groups seeking legal recourse or redress in cases of disputes or harm resulting from GMO-related activities. Ensuring a clear, comprehensive, and accessible regulatory framework is crucial to providing avenues for justice and protection for all stakeholders. Which leads me to the second point, which is public awareness and participation. We must acknowledge that right now the public does not really talk about that. Still, there is limited public awareness and participation that significantly affects access to justice. When the public lacks awareness or involvement in decision-making processes, as in our case, it hampers their ability to protect their rights and interests. We recognize the need to empower communities with information and platforms for participation to enhance their ability to seek justice and advocate for their concerns regarding GMOs. This is an issue of concern that my organization has in the activity plan for the next year to make the public aware of the topic and situation in the country. Teach them why it is important to participate in these processes and how that would change their lives in the future. Lastly, I would say that the third key challenge is the enforcement of regulations. So even though that we do have some of the laws and some of the declarations signed and ratified, the last challenge is the fact that the public does not believe in enforcement of regulations. The general thought is that we have a lot of protocols and conventions signed and ratified, but having in mind that North Macedonia is not a member state of the EU, there is no one to control the enforcement of broad laws and regulations. Weak enforcement mechanisms directly impede access to justice for affected individuals and communities, which happens quite often in our country. Next slide, please. To be fair, there are positive trends as well in the southeastern region of Europe. In these years, we have enhanced regulations, which means that in the past few years, Southeast Europe has shown commendable progress in enhancing regulatory frameworks governing LMOs and GMOs. Efforts are underway to align this regulation with international standards, ensuring a more robust and comprehensive approach to biosafety and GMO-related policies. This positive trend contributes significantly to ensuring better access to justice by providing clearer guidelines and legal certainty. Next is the increased public engagement. Even though I already mentioned that in my country, North Macedonia, the public is not very acknowledged nor very participative in the topic, the situation in the region is quite positive, meaning that in Southeast Europe, there is a rising emphasis on public engagement in discussions and decision-making processes concerning GMOs. Awareness campaigns and initiatives aimed at educating the public about GMOs and encouraging their active participation in these discussions have gained momentum. This increased public involvement fosters a more informed society capable of understanding the complexities and implications of GMOs. The third thing that I would mention is the capacity building, which means that investments in capacity building for institutions responsible for monitoring, assessing, and enforcing GMO regulations have been a positive trend in the Southeast Europe. Strengthening institutional capacity plays a pivotal role in ensuring the fair and consistent application of laws related to GMOs. By improving the expertise and resources available for monitoring and enforcement, countries in the region are better equipped to address violations and to ensure compliance with GMO regulations. This trend contributes significantly to fostering an environment where access to justice is enhanced, ensuring that stakeholders are treated fairly and equitably under the law. This is something that really helps both government officials and NGO representatives, having all stakeholders not only on board but truly educated in the topic drives the change more effectively, in our opinion. Next slide, please. I would also shortly focus on what are the negative trends. The negative trends, I will begin with lack of transparency. One of the prominent negative trends is the lack of transparency in the regulatory processes. Insufficient transparency in how regulations are developed, implemented, and monitored creates a climate of mistrust among stakeholders. This lack of openness leads to legal challenges and hinder access to justice for affected parties. Without clear and transparent procedures, affected individuals or groups may face obstacles in seeking recourse or challenging decisions related to GMOs, LMOs, limiting their ability to protect their rights and interests. Next, I will focus on conflict of interests among stakeholders, including corporations, governmental bodies, and advocacy groups, which can lead to biases and hinder fair and impartial justice in GMO-related matters. And finally, the cross-border issues, which means that differences in regulatory frameworks and the lack of harmonization among the Western Balkans countries and in Southeastern Europe regarding LMOs and GMOs pose significant challenges. This lack of uniformity creates legal complexities, particularly in cases involving cross-border issues. Disparities in regulations across the regions can lead to confusions, legal ambiguities, and challenges in ensuring consistent access to justice. Without harmonized approaches, affected parties may face difficulties navigating legal requirements, impeding their ability to seek fair treatment and justice across different jurisdictions within the Southeast Europe region. Next slide, please. Uh, Finally, I will quickly summarize this presentation with one positive example. As I have already mentioned, North Macedonia's commitment to enhancing access to justice in environmental matters, particularly concerning LMOs and GMOs, is exemplified through its signing of the Cartagena Protocol on Biosafety and the Aarhus Convention. Even though North Macedonia, as I said, is still not a member of the EU, the government tries to continue the work by actively implementing the provisions outlined in these international agreements, which demonstrates a positive trend. The country's efforts to align national legislation and policies with the requirements set forth by the Cartagena Protocol and the Aarhus Convention showcase a proactive approach towards fostering a more just and transparent system regarding LMOs, GMOs, and broader environmental issues. I will end with stating that not only the government, but also NGOs in North Macedonia in the past couple of years have worked a lot on the topic access to justice, have created a network and webpage to make this topic more accessible to the public, have organized workshops and trainings around the country. And as my colleague mentioned, things are changing. A few years ago, access to justice was not a topic that was discussed at all in my country. But it is up to us to make it a daily topic so we can move forward. Thank you for your attention.
Yes, indeed. Thank you very much, Andrea, for this very insightful presentation, experience from your region, from your country, North Macedonia. And I think it's very appropriate that you refer to positive as well as negative experiences and challenges and ended with a positive example and also a perspective for the future. I would like to thank both presenters on this panel, Laura and Andrea, for your very clear presentations. I hope you allow me, Summer, that we take any questions and discussion items on these examples, with further examples to the training session, because in the interest of time and more or less sticking to the time frame which we have, I would now like to allow you a brief coffee break before we move to the training session. Would that be okay? Fine, that seems to be the case. So if you have any questions or reflections, please keep them and put them forward in the subsequent session. Now, colleagues, let us have a brief coffee break, 15 minutes. I hope that will be sufficient. Try to be back at 5 minutes past noon, 5 minutes past 12. I will then hand over, I'm already now handing over to Summer Kern, who will be the facilitator of the training session. She's taking over 5 minutes after 12, will guide you through the rest of the morning until the lunch break, and will continue after lunch for another 45 minutes. So thank you for the moment. All the best for the next session. I'm sure it's going to be interesting. And now enjoy your coffee or refreshment. Thank you.
You can hear me now. Okay, excellent. Yes, my name is Summer Kern, and I'm a senior lawyer, environmental lawyer, and I'm really honored to be here with you. I've enjoyed the presentations so much thus far. I think this is an outstanding opportunity to explore the synergies between the Aarhus Convention and the Convention on Biological Diversity. It's been interesting thus far, and I hope this will continue to be sort of an interesting time. So I know everyone's eager for lunch, but the Secretariat already laid out, both Secretariats laid out very interesting and helpful background information about relevant provisions of the two treaties. And you will just maybe need to bear them in mind sort of as we continue. Thank you. Next slide. So the purpose of this training is essentially to raise awareness of the importance of access to justice as regards to LMOs and GMOs and address some relevant and related matters, and to explain procedures on access to justice and how they work in practice. You have gone through in the previous presentations a lot about each article by article, which is relevant and necessary, but I hope to deal with this now via concrete examples and train with you and ask you questions. So this is aimed mainly at the national focal points of the two treaties, the Aarhus Convention and the Convention on Biological Diversity, but I'm aware that we have other stakeholders in the room, and I'm most glad to have them with us as well and encourage their participation as well. Next slide. So how is it structured? Well, as I indicated, I'm not going to be going provision by provision, but I'm going to give you hypothetical scenarios. I say mostly hypothetical because some of them are in fact taken from real experience that I know from Aarhus parties. As I go along, please, I hope to be able to present things clearly, but if you have any need for clarifying questions, please do not hesitate to raise your flag and ask for any clarification. And please actively take part in the discussions as we try to figure out the answers together. Some of you may be lawyers, some of you may be Aarhus experts, but this training is aimed at all levels. And there may be cases where you, from your own jurisdiction or your own experience, have a gut reaction. Please speak up. Don't leave it also for the lawyers or experts in the room. And I will, at the close of each question, do some summing up remarks so that everybody's on the same page in the end. We know what we're talking about. For the most part, I'm not asking you to evaluate other parts of the convention, such as the provisions on access to information or public participation, but I could not entirely avoid doing so because these elements are directly incorporated by reference into Article 9 dealing with access to justice matters and are therefore important for a court or other body that is evaluating access to justice claims and procedures. And we already had today and yesterday some very, very helpful presentations from the secretariats as regards to the other aspects of the convention, access to information and public participation. So I think as Marina and Micah helpfully pointed out, there are important things to keep in mind as you're addressing these scenarios. Things like who, what, and how under the Article 9 of the Convention, thus who's entitled to bring the case in question, what sort of challenges may be brought, how can the procedures be carried out, and using what modalities. Next slide, please. So to dive in, I know that the script is small, so I will also read it for you, and I can remind you of any of the factual aspects if it's unclear. Scenario 1. It is a group of citizens. They come together to form a so-called citizens initiative named Aarhus Rights Now, because they're concerned about GMO releases in their community in Burbank. Aarhus Rights Now requests of this municipality, Burbank, in the country Caledonia, information relating to a cost-benefit analysis that Burbank undertook as part of its decision-making to permit the release of GMOs in trial fields, and secondly, any fines that Burbank imposed on permittees for unlawful releases of GMOs. So two things, a cost-benefit analysis and information about fines imposed. I will try to make the hypothetical scenarios more simple. So assume that Burbank is a public authority, and assume also that Caledonia is a party to the Aarhus Convention, and assume that citizens' initiatives like Aarhus Rights Now are recognized under Caledonian law and practice. Now, Burbank, who was requested this information about the cost-benefit analysis and the fines imposed, rejects Aarhus Rights Now's request on the basis that Aarhus Rights Now has no legal character. It is not an environmental NGO. It is not an individual person. And so it demands, rather, that Aarhus Rights Now resubmits its request in the name of an individual member of the citizens' initiative. Aarhus Rights Now appeals to the Ombudsman for Environmental Information, which is responsible for appeals concerning access to environmental information requests. This is the key point for you to keep in mind. Now, Aarhus Rights Now argues it should be entitled to this information, even though it is a group of individuals without legal character. So my question to all of you is, based on what you heard earlier today and yesterday, based on your experience or even your gut feeling, how should the Ombudsman decide? How relevant is it that Aarhus Rights Now is a spontaneous group of people, individuals coming together, making this request? Is it okay for the public authority to say, no, you need to resubmit in the name of an individual? Any takers? And are there any clarifying questions needed? For example, is the question having a legal character, for example, something that needs to be clarified? Albania, please.
Thank you. If Caledonia is an Aarhus member, then the group of citizens does not have to have legal status in that country. They are natural subjects requesting information from a public institution, and they have the right to do so.
Excellent, very clear answer. Does anyone want to add to that? No? No? All right, then absolutely. So the answer is absolutely correct. It falls under Article 9.1 of the Convention. It is a legal challenge for the failure to answer an environmental information request. And Article 9.1, as Marina and Micah sort of discussed yesterday, follows the everyman person, every person model for standing. So that means that any person who feels that their environmental request was not answered or not answered in full, or there was other procedural irregularities like delays with the way that their request for information was handled, is entitled under Article 9.1 of the Convention to bring a challenge. And here it's really, it's helpful to consider the definition of members of the public under Article 2.4. This is a group of individuals. And so they should be entitled to the information. I gave you extra information in this case, where actually they are recognized under law and practice in that jurisdiction. So they are also a group or association recognized under law and practice of that, which is just, and I think even without that fact, they should be entitled to the information. But this just makes it even more clear that they should be entitled to this information. Yes, I see a question.
Would then the information be become public, or would it only be provided to that group of people? And also, would the state the Burbank have the right to have the complete list of individuals involved in that organization?
That's a good question. So generally with the environmental information requests, this information would be then delivered to the requesters, that it would not follow that it would be made public. Whether or not this information, and this is actually based on a specific case, they and the rejection was made. This was a case which actually involved an Article 6 decision making, and this information should have been made public, but wasn't. But so the citizens' initiative in this case should have gotten the information before. They didn't. They submitted an access to information request, which was denied. Now the ombudsman, as Albania pointed out, should correctly decide that despite not having a legal character, they are entitled to that information. That would not follow the information is made public. As to whether the information about the information requesters is made public, no, generally that would not be the case. So is that clear?
I meant, would Burbank have the right to have the complete list of individuals involved? And that, not that the list would be made public, but that the government would know, local government would know.
This is a good question. I do not believe so, because again, for these purposes, it would be different for the if they were operating in the Article 6 context, where it is required to have the name and address and other information to prove that these people are entitled to come together to form a citizens' initiative. For purposes of an access to information request and a legal challenge thereon, assuming that they formed this legitimate citizens' initiative, that information should not be relevant for the public authority and not for the court, and would not be made public. No. So I think we've got that. Any other questions as to this question? But again, take away, every man standing. You should be. It does not matter whether or not this organization had legal character or not. The information should be given. Mexico. Microphone, please. Microphone.
Here the the last sentence, yes. The legal character.
Yes, I think at the outset I asked if there were any questions about that. So essentially, legal character in some other places, it's called legal personality. This is used to describe organizations, whether they're companies or registered environmental NGOs, who have a certain legal status. They have to go and register and fulfill certain criteria to the authorities. And this gives them certain rights, like the right to sue, obligations, that they also have the right to be sued. They have to do reporting requirements, pay taxes, file things with the authorities, etc. But in this case, this is a spontaneous group of individuals which formed directly in response to concerns about potential GMO releases in their community. And as I added, so this is a real example from Austria, actually, not concerning GMOs, but it's from Austria. Austria recognizes that these spontaneous groups can come together, and they have status under our environmental impact assessment laws. So that's what I mean by legal character. Does that answer? Okay. Then if we're clear on this, I would suggest we move along to the next, yeah? Okay, so assume that the Ombudsman declares that Aarhus rights now cannot be denied the information on the basis that it is just a group of individuals with no legal character for the group itself, just as Albania suggested correctly. However, Burbank then argues that the cost-benefit analysis Burbank undertook and any fines imposed on the permittees for unlawful releases of GMOs are not environmental information and again refuses disclosure. Aarhus Rights now appeals again to the Ombudsman. How should the Ombudsman decide? And this is one where I flag for you. You have to go back in your minds a little bit to some of the discussion that, that Marina gave the other day about what is environmental information, and I can assist you. We should not dwell on this one too much, but it is important because a court will not have jurisdiction. It will not have the power to decide on this unless it is established that these two things, or at least one of them, qualifies as environmental information within the meaning of the Aarhus Convention. So cost-benefit analysis that was used in the decision-making in order to release GMOs in trial fields, and information about unlawful releases of GMOs and fines imposed on people, parties, companies for those unlawful releases. Anybody have any, even just gut feelings? Should this be environmental information or not? Please, microphone.
The Aarhus Convention, we can clearly understand that any information dealing with GMOs, which is potentially important for environment, for human health, etc., is a part of interest of the Aarhus Convention. In this case, it is the case.
Excellent, thank you. Does anybody disagree or want to add anything? Yes, I see Kenya.
Thank you. I'd like to find out why would the rights group, the Aarhus right now, complain, yet I thought the decision of the Ombudsman seems to agree with them, or to compel Burbank to give the information. Why are they complaining?
Yes, sorry, maybe the scenario was not clear enough. The point is that the Ombudsman has several questions to answer. So first, the first barrier that Aarhus Rights now encountered was they were told they are not entitled to this information because they are just a group of individuals who came together spontaneously. And the Ombudsman agreed with them, but that does not mean that Aarhus Rights now gets the information. So there are further challenges. And the next challenge that, that Burbank, the public authority, is making is that, well, okay, maybe as people, they have standing to bring this case. But we maybe are not giving you this information because maybe it's not environmental information and you are only entitled to bring this case and have it ruled on if this is an environmental information. Yeah? So, so what Ilya said is absolutely correct, that this is absolutely, these two pieces of information are environmental information within the meaning of the Aarhus Convention. Marina mentioned it only in a sentence, but under Article 2.3b, that this cost-benefit analysis, which I said was used in the, sorry, do you want to speak first, Georgia, before I sum up? Please.
I want to say something about the cost-benefit analysis. According to the Aarhus Convention, there is no obligation from the public authority to elaborate additional documentation or work some to create additional documents in case it was not request on to this activity was not subject of EIA, they will not have this information. Yes, if yes, they have, and they have to provide this one. If not, in my understanding, it is not an obligation to work on additional documents. Am I right? Thank you.
That's an excellent point. I don't know if everybody understood that. I mean, so the question is, can an NGO request information that maybe the public authority was not obliged to create in the first place? So do they need to make something extra so that they can then provide this information that was requested? And there the answer is generally no. However, in this scenario, so 2 points. One is, in the scenario, I already said that the cost-benefit analysis was done, and it was done specifically and relied on for the environmental decision-making whether or not to release the GMOs on the field. So it exists, and it was used in the environmental decision-making. So that's a different situation from what you're proposing. The only thing I would add to that is no, the public authorities do not need to create whatever documentation that the public thinks they need under the Aarhus Convention generally, but there is under Article 5 of the Convention the requirement to possess and update information that is relevant to their decision making. So there is a grounds for refusing access to information requests by saying we don't have this information, but always with the caveat, if they have it, if they used it, if it's relevant to the decision-making, it should be disclosed. And some information may be something that they are required to possess and update as part of their work. But essentially in this case, cost-benefit analyses used in environmental decision-making, which could have an effect on this was used whether or not to permit the release in these trial fields. It is environmental information and under Article 2.3b. And the fines for the unlawful releases of GMOs, I would say, is likely an administrative measure under Article 2.3b, affecting or likely to affect the environment, water, soil, biodiversity, and an important one at that. So I would agree with Ilya that this information should be disclosed. So that is settled. Assume that, moving on to the next little assumption, assume that the Ombudsman can issue binding decisions on Burbank. It says Aarhus Rights Now is entitled to the information. Burbank has to release the information. But Aarhus Rights Now, for some reason, is complains because it says the Ombudsman is only an administrative review body, and this does not fulfill the requirements of the Aarhus Convention, which requires judicial review. So is Aarhus Rights Now correct? Is there a problem with having administrative review for complaints concerning to access to information requests? Are they right? Sure, Albania.
just to clarify, they did not, what are they called again? The Arrows rights now. Did they wait for the ombudsman reply or not? Oh, no, I'm sorry. I meant after the ombudsman decision that they have the right, the public institution has the right to reply to them. Did the public institution reply or not? If they didn't get the information and if they acted before getting the information?
I didn't put that into this to the facts, but I said that the ombudsman can issue a binding decision, which means we can only assume the public authority will have to release the information.
They have to, I think.
Anyone else? Every person likes their day in court. It's very important. So is administrative. I see. Kenya, please.
Sorry, once again, this is the point that I was at in my previous intervention or
Yes.
in my previous question, when it reads that it is the rights group that now feels not happy, yet the ombudsman has given directions that information be availed to them. So that this is where, sorry, maybe I jumped ahead, and that's the clarification that I intended to find out. Why would the rights group feel not happy with that potential decision to be for the municipal group, company to give information? Thank you.
Excellent, thank you. And your point's very clear and very on point. I see now European Eco Forum.
Aarhus rights now might not feel happy about this process, because if they think, well, we had the right in the first place, why did we need to put out all our effort in now also talking to the ombudsman to convince them? Why didn't we get it in the first place?
Thank you. This is also a good point, because indeed they had to deal with multiple challenges going back and forth to the ombudsman, and this there are no facts there, but this could have been an issue of real timeliness. They need the information fast, and they're not getting it, and for reasons that are rather silly. However, they just got a binding decision. They should be happy. So the answer is essentially no. You do not need a court of law. Aarhus Rights Now is incorrect. Administrative review that is resulting in a binding decision should be sufficient. In fact, it's highly desirable. Many Aarhus parties use ombudsman or other review procedures, and it serves great functions. Sometimes they have specialized knowledge in these cases, where they can actually deal with the matter much more expeditiously, which is desirable in access to information cases. And they're less costly, and they work faster than courts. And I brought this up because most commonly in parties, this is used very often for access to information requests. Many parties use an ombudsman for this, but also Article 9.3 of the Convention dealing with contraventions explicitly provides for either judicial or administrative review. And also Article 9.2 of the Convention, which is dealing with matters falling under Article 6 of the Convention, primarily dealing with specific projects, that also calls for review either by a court of law or other impartial and independent body. So Aarhus Rights Now has a meritless argument that the ombudsman is the body in charge of dealing with its requests for review under this procedure. Bearing in mind, of course, they may be very frustrated by the public authority and having to go back and forth with regard to their requests. Next slide, please. Okay. Now I'm asking you to imagine a scenario that is a little bit different than what we just discussed. So assume the the Ombudsman decides that Aarhus Rights Now is entitled to the requested information, but and the Ombudsman only has the power to recommend to Burbank that it release the information. According to the law in Caledonia, the Ombudsman cannot compel Burbank to do so. So to get a binding judgment, Aarhus Rights Now needs to go to a court following the Ombudsman's decision, and this will cost 80,000 euros and approximately 8 years to get. So what, if any, issues with this legal framework and practice in Caledonia as regards requests for information appeals concerning LMOs and GMOs can you identify, bearing in mind the presentation we had before? Anything? Mexico, would you like to take the microphone?
That history.
Sad history. Okay. Yes, please. I'm sorry, I don't have your name. You're far away.
Alev Mine of the One Goal Initiative for Governance. So I think the issue there is that, well, there are two issues, I would say. There is the damage that takes place meanwhile, yeah, and then there is the segregation, because I mean, if a party wants to, I mean, a group of people wants to have access to justice, and they need to be rich. Then there's I guess, a social segregation about who may or may not get their rights.
Thank you. Well put. Does anyone want to add to that? Albania?
Thank you. I see three problems with the legal framework of Caledonia. First, it is not very effective to have an ombudsman who is just has recommending powers. It does not solve anything. So it means every person or NGO that would have a claim against a public institution, they will all have to resort to the judicial system, which will be translated into an overburden of the judicial system, which is translated in the 8 years, the duration. So first is the consultative powers of the ombudsman. Second is the high cost, whereas we know that environmental information is supposed to be free, so it's not free, and the judicial system also becomes more like an obstacle to get that information, that really get access to that information, and the duration of the process is also another obstacle to get free environmental information. So these are three problems that I see with the legal framework of that country.
Absolutely. I think both of the interventions are completely on point, and it leads to this problem of discrimination. Also, you know, you have to be rich in order to bring cases, or be willing to go into bankruptcy in order to do so. This is also from a real country. Yeah, there's a problem. The ombudsman cannot issue anything binding, and so you need to have a binding decision. You have to go to court. The courts are take a long time. 8 years is incredible. That's really long, and 80,000 euros is so. There it's invoking in particular Article 9.4 of the Convention, which requires of all procedures that they not be prohibitively expensive, and that they be timely, and this runs afoul of both of them. So it's a big problem, but it's a real issue. This happens in practice sometimes. Mexico?
What will happen with the economic impacts? What will happen with the environmental effects? It's a sad history in many countries, in Mexico is a sad history with soybean, because in 10 years ago, the government released the GMO soybean, and now the effects with the GMO is terrible, with the contamination, pollution, the water, the air, the soil, all the people. It's terrible.
Thank you for that. Thank you for that input. Yes, that's highly concerning. If there are no further questions, we have some more scenarios to go through. I would ask to move to the next slide. So this is scenario B. ENGO Do Right By Us is based in the country Ether. ENGO Free From NGOs is based in a neighboring country, Gaia. A public authority in Ether granted licenses to plant GMO enhanced corn in the environment in an area directly bordering Gaia, into which the wind routinely brings pollen and small residues from Ether. Assume that the license granted concerning GMOs is for a project that falls under Article 6 of the Convention. Assume also that Ether and Gaia are parties to the Aarhus Convention. Do Right By Us challenges the licenses to plant GMO-enhanced corn in court, arguing two things. First, it was given no chance to receive information concerning the proposed license to plant GMO-enhanced corn, nor the opportunity to comment on this proposed activity. And secondly, Ether's decision failed to reduce any risks associated with the license to the effective 0 level. In court, the lawyers argue for Ether first that ENGO Do Right By Us is not entitled to challenge the licenses to plant GMO-enhanced corn, as it could not allege these licenses resulted in an impairment of its rights. So first, there are multiple issues in this scenario, but I'm first asking you to concentrate on the question. The Ether is saying that this ENGO cannot show an impairment of rights to bring these challenges. So who would like to weigh in on that one? And everyone is welcome, including Albania, but I'm also looking forward to hearing, and Kenya, but I'm looking forward to hearing from some new voices, if they were listening to the presentation on public participation earlier. And in the interest of time, I can also cut things short, but I really am interested in your engagement and thoughts. Is it okay, to formulate it differently? So I asked you to assume this is Article 6 decision-making, and somebody's bringing a challenge to Article 6 decision-making. Do you recall which provision of the convention under Article 9 is relevant for challenges relating to Article 6 decision-making? Which one is it? Article 9.1, 9.2, or 9.3? Okay, I will say in the interest of time, it's Article 9.2. Article 9.2 of the convention provides specifically for review procedures related to Article 6 decision-making. And again, Article 6 concerns certain projects that may have a significant impact on the environment. I see European Ecoforum, please.
Sorry, building on your scenario, given that all Aarhus parties, with one exception, are also parties to the Cartagena Protocol, This would also be Article 17 of the Cartagena Protocol about unintentional transboundary movements, whereby states have to notify neighboring states if there has been a transboundary movement of an LMO.
Excellent. I like that. And hold that thought because we're coming to that as well. No, perfect. But just at this moment, we're talking about the domestic NGO and they're, being attacked for having standing because they're an NGO and cannot show an impairment of rights. Because we're running out of time, I will just say, if you recall from Article 9.2 of the Convention, that NGOs meeting the necessary national criteria are presumed to be able to fulfill the requirements of either having an interest in or impairment of rights, whatever is required of the national system. So you cannot deny the NGO standing saying that they have no impairment of rights. That is only relevant for individuals. It would arise if, say, you had an individual farmer who was concerned about these releases. Maybe the farmer has neighboring properties and is concerned about having its own fields contaminated by these releases. They might have to show in their jurisdiction either having an interest or having an impairment of rights, which would probably be met in this case. But this is something that a recognized NGO does not have to fulfill. So the answer is no, it's a recognized NGO. They should be given standing. Next slide, please. So I hope we can finish these before we end. And we already got a good start. So the second issue is the Lawyers for Ether argues that as an ENGO, do right by us. Okay, they have standing generally because they are an ENGO. They don't have to show an impairment of rights. But they're only entitled to bring challenges, the what, so they are the who. They have the key to get into court. But they're only allowed to bring challenges as to the failure to receive information and comment on the activity. And it was not entitled to bring the legal challenge as regard the claim's need to reduce the license to the zero level as regard risks. So yes, you can complain about lack of information and inability to comment, but as regards the zero level of risks, no, you have no standing. How should a court respond to that? Or in other words, what issue is being raised here? And remember the WH questions. So there's the who, and now we're maybe talking about the what. What challenges can we bring? And this is also coming from a real life example in a party. They've since changed their laws, but this is from a party I know. I won't name and shame, but this was an issue before. Is it okay if the NGO can only bring claims about lack of information and zero level of regarding risks? Let me give you a hint. So how do you understand what these different arguments are? So the argument about we didn't get the information we wanted and we didn't get the information opportunity to comment. How would you characterize that kind of claim? And the answer is those are claims about procedural legality. And we talked earlier today about what needs to be challengeable under the Aarhus Convention, and it was procedural legality. So they need to be given that standing. They need to be able to be allowed to bring this challenge. Their public participation rights were violated in this case. Does that make sense? This was Article 6 decision-making. This was a permit. It falls under Article 6 decision-making, which relates to specific projects that may harm the environment. And they're making a claim that their procedural rights were violated in that decision-making procedure. But then the second claim that the decision with regards to the failure to reduce the risks to zero is different. That is substantive legality. And as you may recall from the discussion earlier today, for this decision-making, it is really, really important. An NGO or other qualified members of the public concerned should be able to bring challenges both as to procedural legality. If something in the procedure was incorrect, their procedural rights were not observed, to comment, to be notified, to get information. But they should also be able to bring a claim as to substantive legality. But again, I emphasize this is just the key to the door. It does not mean that they will win, okay? So on the merits, they may lose. Kenya, please.
Thank you, Madam. The second issue of the need to reduce the license to the zero level as regards risk, in my opinion, that is premature because the information hasn't been made available to inform that kind of demand. It appears to be coming a little too early in the process. Thank you. My observation, my position. Thank you.
Thank you. That is a good observation. And maybe my hypothetical was not complete enough. So my understanding is the license has been issued, and so the releases will be made. And so maybe the risk assessment should have been done prior to that decision making, because now the damage can occur. I'm stopping here. But I agree with you. You would have to look at the law in question. Does the law in question say that the risks have to be reduced to zero? And if not, and likely not, and this is from a real case, then on the merits, they will lose their case. But the question is, as to their standing, can they even bring these arguments in the first place? And the answer is, this is a substantive legality question, and they should be able to bring this case. And with that, I think we have to stop.
Well, thank you, Summer, and thanks to all of you. I think this is an excellent interactive session. I really admire the way how you handle it and the way how you intervene. Just a brief organizational point from my side. We are now breaking for lunch. Please be back at 3 p.m. when we are going to continue with this exercise, and we will discuss for how long it can take place in the afternoon. Enjoy your lunch and see you at 3 p.m. again here. Thank you. Thanks.
If my mic is, yes, it is now. Okay, welcome back, everyone. And I hope you were able to get some nice refreshments, hopefully feeling full of energy now, not in a slump from eating too much. Just to take us 1 second back from where we were looking at this scenario B, which, to recall, concerned a project that was subject to Article 6 of the convention, in that it was a project with likely potential negative impacts. And the conclusion we reached following this question 2 is that as an environmental NGO, Do Right by Us is entitled to bring both challenges as to procedural legality and substantive legality. As I said, this was a problem in the past where In another country, a party to the convention, NGOs were only given standing as to challenge procedural legality, and this has been since rectified. So getting on to a rather different issue, which we sort of touched upon a little bit by an intervention from Ecoforum. The next little question I have to answer is, if you recall, ENGO Do Right by Us was based in the country where the releases were occurring, but there was this other NGO, free from GMOs, and they are located in a directly neighboring country, also a party to the convention. And they assumed that they brought a separate lawsuit against the license that Ether, the public authority in the other country, granted. Ether now argues that Free from GMOs has no standing in courts in Ether because it is a foreign organization. And the question to you all is, how should a court respond? Based on, do they have standing? Or is there a problem indeed because they are a foreign-based NGO? Anyone? Even a gut feeling? Does that sound right to you? Perhaps I'll recall some of the facts also. It's not just any foreign organization, but it's located in a directly neighboring country. And the fields being where the releases are licensed are occurring right next to the border. And the winds routinely bring pollen and other plant matter across the border into the country where Free from GMOs is located. Do you think they should have standing in the court? I see some nodding. Would you like to share your thoughts? Is that Germany? Yes, please.
So it feels very incompetent, but yes, if you're asking for a gut feeling, I think they should have standing. They are clearly impacted. Yes.
Very interesting. Does anybody want to build on that, or does anybody disagree? Think that there's a problem, that the court should say, no, you're foreign, you're out of here. You don't. Kenya, please.
To share experience from the Kenyan side of a similar situation. But in this case, the group of NGOs located in a neighboring country, which is a member of the East African community, went to the East African Court of Justice, which has regional jurisdiction. So in that sense, therefore, in our case, they have standing. In this particular one, probably it would depend on the national laws of this particular country, whether they allow official standing of entities that are foreign, probably other laws. Thank you.
Thank you for that. Also, a very good point. You would have to, I think, look at the national laws, which differ in some instances. And I know that even among the parties to the Aarhus Convention, they have different provisions of law that would provide for standing or whatnot. But first, just to stay with the Aarhus Convention, which all of these parties are obliged to. They may have their different national systems, but all the parties have to abide by the Aarhus Convention. And here one particular article of the convention is implicated, and that's one that was touched upon earlier, I believe today or yesterday, and that's Article 3.9 of the convention, which says that it prohibits discrimination in the exercise of Aarhus rights, not just public participation rights. I believe it came up as they were speaking about public participation, but the exercise of all Aarhus rights on the basis of citizenship, nationality, domicile, or in the case of legal presence, like our NGO here, its registered seat or effective center of activities. But I also want to come back to the point that Germany made, which I think is right on, is even if we didn't have Article 3.9, based on the fact that this NGO is likely affected because the GMOs have a very, very likely impact, also transboundary effects on them. Just alone by looking at Article 2.5 of the Convention, very likely they are being, they also can show that they have a potential, effectiveness. But that effectiveness is bolstered by Article 3.9 of the Convention, which prohibits this discrimination on the basis of citizenship, domicile, or registered seat, or sphere of activities. But it's not just the Aarhus Convention, which is relevant in the context of GMOs and LMOs, but as Ecoforum pointed out, there are some further provisions which are relevant here. So please, Ecoforum.
Yes, thank you. Yeah. Sorry. Assuming that one or both of the countries involved are members to the Cartagena Protocol, the Article 17 of the Cartagena Protocol would apply. And that's the article on unintentional transboundary movements and emergency measures. And that requires the country where the GMO is to notify its neighbors if there is, if there has been or may lead to unintentional transboundary movement of LMOs. So it wouldn't actually need to be up to the NGO in the neighboring country to take this forward. It should actually be the neighboring country itself protecting its farmers. Thank you.
Thank you for that elaboration. That's really interesting and helpful. And it just goes again to show that there's some very interesting synergies between the two treaties. I would only like to, as a very final remark, just put one thing out there, is I made the scenario very simple because I said that both of the countries in question are parties to the Aarhus Convention. But I should add that even if the foreign-based NGO in a bordering country was in that country, it was not a party to the Aarhus Convention. The obligations that parties to the Aarhus Convention undertake are to the public and the public concerned. And so it actually should not be a determinative factor whether that neighboring country is a party or not to the convention. In this regard, it's different than what Antje just mentioned, and different from the ESPO Convention, which are agreements between parties, and the rights of the public are sort of dependent on that. The Aarhus Convention is different. So not a critical point for this scenario, but something for you to keep in mind. So, so that's the takeaway from this example. We can go to the next slide and our next scenario. Oh, a little hard to read, sorry about that. I'll read it to you. So now ENGO Help the Good Use of GMOs, so it sounds like they're GMO friendly, is concerned about the regional zoning plans in the region Ithaca, which banned GMO cultivation in that region solely on the basis of a report concerning the effects of GMOs on local flora and fauna, which was never shared with the public. It therefore brings a challenge at these zoning plans. Assume Ithaca is a region within an Aarhus party, and assume that Help the Good Use of GMOs is a recognized ENGO in this party. Help the Good Use of GMOs argues two things. First, that the fact that the report concerning the effects of GMOs on local flora and fauna was never published violated its procedural rights. And second, that the zoning plans are inconsistent with binding national law requiring that regions establish zones where GMO cultivation is allowed. Ithaca argues that Help the Good Use of GMOs has no standing as to either claim. So again, we are looking at the question essentially of who has the key to open the gate, the door to the court. So as regards to the first claim, how should the court rule about the fact that this report was never published, violated the procedural rights of this recognized ENGO? Anyone? And it may help you to, again, always as a threshold matter, consider, okay, well, what sort of decision-making are we considering here? Is this a project, a specific project, or is this some other form of decision-making relevant for the convention? Because that may or may not change the way we approach the issue of what kind of legal challenges they can bring and who can bring them. So does anybody want to start, either jump ahead to say, do they think that this ENJO should be able to bring this first claim that its procedural rights were violated? Or if you want to jump into the threshold question, well, what kind of decision-making is at issue here? Is it for a specific project? Albania, I see you, please.
Okay, so in my view, we're talking about planning and programs with an environmental impact. And clearly, Ithaca has not respected public consultation procedures with regard to decision-making on environmental planning and programs. So I think they have a standard.
Excellent. Did everyone get that? So Albania correctly pointed out, we're not dealing in this instance with a specific project. So we're not directly under Article 6 of the convention, but we are under Article 7 of the convention, which specifically deals with public participation as regards to plans, programs, policies, etc. This happens to be a zoning plan. And zoning plans are very classic examples of Article 7 decision-making plans. And you are absolutely correct that given that these public participation provisions of the convention are triggered, that the public was entitled to certain procedural rights. And you think in this instance that the procedural rights were violated? Can you be more specific? So what was the violation exactly?
The party, they held the good use of GMOs, whatever, they should have been informed in advance. I mean, this involves early consultation, so there was no early consultation, there was no consultation. They were just presented with a fact, with a decision that is reached, and that's it. So early consultation, all procedures with respect to consultation process were not respected from what I assume. But I'm not a lawyer, so
Well, you're doing very, very well. I don't think that one always has to be a lawyer to be able to understand these critical things. And absolutely you're correct. And probably from the facts, it looks like indeed many procedural violations are present, but one was this report was not shared. And we know that this report was used in the decision-making. So this is a procedural issue. I can tell you, and this procedural violation should be challengeable under the Aarhus Convention. Under which provision? This is a slightly trickier issue, and I can get into it in the break or afterwards with any of you if you wish. But traditionally, the Aarhus Convention Compliance Committee has analyzed these under Article 9.3 of the Convention and ruled and found that these procedural violations are also challengeable under Article 9.3 when there are procedural violations relating to Article 7 decision-making, which covers plans, programs, etc. So are there any more questions, or is that point more or less clear? If it's clear, then I'll move on to the next slide. So we've already sort of touched upon this, the bonus question. I guess it's not strictly speaking an Article 9 access to justice question. What, if any, facts are relevant to understanding the merits of help the good use of GMOs claim that the procedural rights were violated by the fact that the report was not shared. And we sort of went into this, but I don't know, just to tease it out a little bit more. But we don't have to dwell on it because we don't have the scenario. We can go back to the scenario if you want to read the facts, or I can tell you that there's one little crucial fact in there. It's not just any report. Okay, I think in the interest of time, I would just tell you the facts, and because we don't have the scenario in front of us, in the facts, I told you that Ithaca made this decision, this regional zoning decision, to forbid the planting of any GMOs in this specific territory, only on the basis of this single report saying that the GMOs would damage local flora and fauna, which means, I mean, that was the entire basis for their decision-making, which makes it necessary information. And Article 7 of the convention, among other things, so it requires reasonable timeframes. It requires that participation be early and effective while options are open. It requires the public authorities to take account of the outcomes of the public participation, but it also and crucially requires a transparent framework in which the necessary information is provided to the public. And there's no question, if this was the entire reason why this decision-making body said, this is what our regional zoning plan is going to prevent the GMOs, then it is clearly the necessary information. So that's the little bonus issue for you to keep in mind. The second issue, how should a court rule as to the standing to assert the second claim concerning the alleged inconsistency between the regional zoning plan and national law? Does the NGO have standing to bring this attack? Yes or no? And why? I know some of you, like in Germany or certain jurisdictions out there, they might allow challenges like this. Challenges, or in Czechia, we don't have any Czech people here, but are NGOs allowed to challenge things like zoning laws in your jurisdiction? Okay. Shall I move ahead? Shall I jump ahead? Okay. The answer is essentially this. Maybe if you remember the case that we talked about, the scenario B just before the break, that was about a project. And if you recall, we determined that NGOs, these recognized NGOs, must have standing to challenge both the procedural legality of the decision-making and also the substantive legality of the decision. And that is, this scenario is asking essentially the same question, except for as regards to a plan instead of a project. And the answer is, so this second claim about this alleged inconsistency between the regional zoning plan and national law is bringing a substantive attack. It is saying that essentially this regional zoning plan is illegal. It's not consistent with the national laws. And this would be a classic example of a potential contravention of a law relating to the environment under Article 9.3. That would be a substantive challenge to a zoning plan in this case. So you can also see this in the Aarhus Convention Compliance Implementation Guide. Just like in Article 9.2, as regards to projects, yes, challenges for both procedural and substantive legality are required. I will just add, I'm not going to discuss it, but there are some arguments as to why this can also be, in the alternative, argued under Article 9.2 of the Convention. But as I said, talk to me in the hallway about that one if you want to hear more. Next slide. So scenario D, this is my last scenario, so maybe we won't have to go over time. We'll see how engaged the conversation is. ENGO Justice for the Environment is concerned about GMOs in commonly consumed agricultural products. It learns that private cereal company Kellogg's, no intention to reference or suggest any company in particular by saying that, uses GMO wheat in its breakfast cereal products. In the view of Justice for the Environment, Kellogg's fails to adequately label its product as containing GMO wheat. Justice for the Environment alleges this is contrary to the laws in its jurisdiction regarding product labeling for commonly consumed agricultural products, and therefore undertakes a publicity campaign to share its view that Kellogg's is marketing products containing GMOs while failing to disclose the presence of GMOs in these products. And it brings a lawsuit against Kellogg's for what it considers a breach of national laws relating to the labeling of products containing GMOs. Any questions? Should I read it again? Or is it clear? I can also go back to it afterwards. But essentially, GMOs potentially in cereal, and the NGO thinks that this is not labeled properly and that this violates the laws concerning the labeling of products containing GMOs, and so they sue Kellogg's, the cereal company. Okay, then let's move on. Next slide. So Kellogg's responds, firstly, it defends itself and it says, as a private cereal company, Kellogg's cannot be challenged by an ENGO for any alleged violation of national laws relating to the environment. And further, as an ENGO, Justice for the Environment is not a competitor of Kellogg's and therefore cannot bring a challenge against Kellogg's. So the first question is, how should a court respond as to Kellogg's claim that it cannot be challenged due to its status of being a private company? Is Kellogg correct? If so, Kenya, please.
No. A private company, by definition of one of the articles that you shared, is a natural, can be a natural person or a corporate. So it is not right to say as a private company can be sued. But then I see one of the two issues raised. If you could go back to the earlier slide. Yes. First, the NGO has gone to the court of public opinion by initiating a publicity campaign to share its view that Carl is marketing products containing GMOs while failing to describe or to disclose the presence of GMOs in these products. And then he also goes to the court of law and files a suit against Calgraph. So it is taking two approaches, one of which is within the court of public opinion and the other one within the legal system. Now, going to the next slide, I would say that next slide, yes. The 2 points are not admissible. As a private company, Calgraphs can be sued, and as an NGO, it has a right to sue within national jurisdiction. Again, I'm not a legal expert. It is out of gut feeling. I could be wrong. Thank you.
Gut feelings are very welcome, especially in this forum. No, we need to discuss things. I mean, sometimes there's the law, but the law is also not supposed to come out of nowhere. We want it to make sense, and it's important that we use our critical minds to question behind it and see if it works. But do I understand correctly? So you are absolutely right. They did two things: challenge sort of in the public opinion with this publicity campaign and going to court. Did I understand you? Did you say that can they sue the private company? Yes. Yes. Okay. And the fact that they're a competitor, is that a problem? Or not a competitor? Not a problem. So you think that the court should allow both claims? Okay. Okay. Good. Does anybody have anything they would like to add to that? Any further thoughts?
For me, it's crystal clear that it's a question of not of competence, it's environmental question. So you cannot, as a wishy-washy to try to, this allegation is not adequate for this case. So it's environmental matters. So you must apply the Article 9.2 of the Aarhus Convention in this case, as far as I know.
Article 9.2? Yeah, it's not clear that we have a situation where we have a public authority taking either decision on a specific project or issuing a plan, program, or policy. But so I think we are more safely in Article 9.3 territory. But are you saying that you think you don't see the link to environmental matters? Sorry, microphone.
Of competence, it's a question of environmental issue. So it's a mistake for the company, as far as I know. I can understand they use this type of arguments, but I think it's not consistent at all, from my point of view.
The company's position is not consistent, or the claims that the claims that are being brought are not consistent. Okay, and you raise actually a very, very important aspect, and one which in the last example I kind of didn't get into, so I'm glad that we got a chance to get into that. So please correct me if I am misstating something you say, but if I understand correctly, the a delegate from Spain, or I realize you're maybe not here to represent Spain, but yeah, so you're from the court. Yes. So he's suggesting that he sees a problem with the claims of the NGO because he does not see this sort of environmental link. And therefore doesn't understand, it's not clear the relevance, the applicability.
The question is an environmental matter. So you cannot use this type of argument of problem with another company, because you are making up a different question. You're introducing something that is different from the matter. That's my point of view.
Okay, thank you. I may or may not have fully understood. So when I go to my explanation after we hear from the others, I see another flag raised. I will explain sort of my thinking behind the case, and we'll see if it addresses the concerns that you raised. But please, I see another flag.
Thank you. I would like just to develop the idea, and can we assume that the consumer of this product go to the court with the appropriate claim? I mean, here in this case, we are talking about the NGO. And what if the consumer of the product, in this particular case, we are talking about the cereal, right? So is there any possibility for the consumer of the product? It could be just a regular family. I mean, do they have an opportunity to go to the court with an appropriate claim? So, yeah.
Thank you. That's an excellent question. And I think that probably under the Aarhus Convention, they could. But the reasoning for why they could would likely be similar to, or at least have some similar elements to why the NGO can go. But even outside of the Aarhus Convention, I think they could bring a consumer claims case as well. Exactly. Now, in the Article 9.2 context, which again, I think does not apply here, because here we're talking about a private company doing things and about the product labeling. But under Article 9.2, for individuals, they have to show, or if the jurisdiction requires it, they may have to show either being affected or having an impairment of rights. But I think as a consumer, if they say, look, it's important to me as a consumer to know what I am feeding myself and my family, that in most jurisdictions, they would probably be able to have standing. Even in Article 9.2, it requires the standing is members of the public, is the term that Article 9.3 uses. But where they meet the criteria under national law, and many national laws, countries will ask for this affectedness or impairment of right of individuals. But I think in many jurisdictions, yes, probably a consumer claim would be admissible, I think. But to go back to the idea of an NGO, so what they are alleging is that there are presence of GMOs in the product, and it is not adequately affected in their product labeling. And this violates their national laws about product labeling of GMOs. And so the question, so we'll get to those aspects, including the one from the gentleman for the court in Spain. How should a court respond to Kellogg's claim that it cannot be challenged? Just focusing on because it's a private company. And we heard from the delegate from Kenya that this should not be winning argument. Does anyone disagree with this? No? Perhaps you can go back in your mind to the presentation of I think it was Marina or Micah, the Secretariat's presentation as to Article 9 of the Convention. And under Article 9 of the Convention, it concerns acts and omissions by, it can be a public authority, but it also includes those by private individuals or companies. So that's a critical aspect here. So Article 9.3 absolutely gives standing, gives the ability to go after private actors. So Kellog's claim that it cannot be challenged because it's a private company and not a public authority, it's not a regulator, must fail because it's expressly in Article 9.3. So, and how should a court respond as to the claim that Justice for the Environment cannot bring a challenge due to the fact that it's not a competitor? The gentleman from Kenya also said he thought that this should fail. And I agree. And again, you have to look at the very wording of Article 9.3. And does it say that somebody is a competitor or has to be a competitor? And the answer is a clear and resounding no. It is members of the public where they meet the criteria under national law. And when you turn again to the definition of the public, it's one or more natural or legal persons, or in accordance with national law and practice, their association, organizations, and groups. So the fact that they are not a competitor should not be a bar to their standing. Now, I bring this up, maybe it seems obvious to all of us, but for example, there's very, very prominent case law in one party in particular, but I think in several, where they really do say in Article 9.3 matters that in order to have standing, you have to show effectiveness, and you are only affected, can only show that your rights are affected if you are a direct competitor. That is a case. It is a case that has been found non-compliant, and we're working on implementation, but that is a very real issue. Does that, I have a few more questions on this scenario, but is it clear? Is that clear for this part? Okay. All right, then let's go on to the next slide. Okay. So moreover, in response to Justice and Environment's lawsuit, CalFux brings a countersuit in which it alleges that Justice for the Environment has defamed CalFux and caused it reputational damage. It therefore demands that Justice for the Environment stop any negative press concerning the presence of GMO wheat in its cereal, and that it moreover pay 10 million euros in damages. So this is getting back to the comments from Kenya, that you note that that there was this appeal or whistleblowing, shall we say, about the presence of GMOs also in the court of public opinion, and a lawsuit. And CalFux obviously doesn't like it, and they're claiming that all of this is ruining their reputation, and probably it will cause them, defame them, and maybe it will make their products less likely to be sold. What, if any, issues are raised by CalFug's countersuit for defamation and reputational damage? Anyone, please. Germany, please.
Does the protection of people who are engaged in, is it on? Does the protection of people who are engaged in environmental activism play in here?
Sorry, can you rephrase the question?
Yes, I was wondering if the protection of environmental activists can play in here.
Yes, I think that is relevant here. I think in answer to your question, it does not have to have been an ENGO. This could have been potentially journalists, or perhaps these consumers that are concerned. But just assume, somebody puts out Facebook posts or puts something on their website, or they put up a poster somewhere, and they also bring this lawsuit saying that the product, I realize I didn't cover one thing. I have to go back, but let's stay with this issue for now. But to answer your question, I think yes, it is relevant that they are that there's an environmental issue, and I need to make that point clear in a second. Shall I go into the environmental nature about this issue, and maybe address that first before we continue with the defamation and reputational damage specifically? Perhaps that makes sense, because that was also an issue raised by the gentleman from the Court of Spain. Yes, okay, so because it's also relevant to your question, I think you were concerned earlier about, well, okay, where do we have this environmental link? Is it present in the facts under this case? It's about product labeling and the presence of GMOs in a product that is being consumed as a breakfast cereal. Is there an environmental link here that people can see? I see Ecoforum, please.
Well, as consumers, we do take environmental decisions when we buy something, be it something that is organic agriculture, be it something that is climate neutral, and that is actually encouraged. So therefore, it would be a consumer's decision to say, I'm buying this or I'm buying this not because it is GMO, and therefore it doesn't has an environmental aspect in it.
Thank you. And please, I see another flag.
Большое спасибо. Я хотел бы буквально из практики, мы видели да, наверное, нужно было представиться. Независимая экологическая экспертиза Кыргызстан. Из практики мы видели, когда есть документ о том, что продукция является органическим. То есть и при этом мы четко понимаем, что при производстве этой продукции использовались земли и вода, загрязненные пестицидами. То есть и также мы четко понимаем, что сертификат, который выдали, не проводил регистрационные испытания. То есть достоверность предоставленной информации ставится под сомнение хотя бы потому, что наши данные по мониторингу этой местности говорят о том, что там повышенное содержание мышьяка, ртути и повышенное содержание пестицидов. То есть если по аналогичным продуктам выходит, ну, например, мы делали картошку, морковку там, и так далее, там молоко, и мы видим, что здесь территория загрязнена, то вот это вот термин органическое земледелие, то есть без использования антибиотиков и пестицидов, он уже изначально является недостоверным. И, соответственно, мы могли бы подавать иск по закону о защите прав потребителя о недостоверной информации. То есть в данном случае, когда мы смотрим на маркировочку, то мы должны четко понимать, что это используется ГМО, не используется ГМО, потому что здесь вообще, когда говорят об органике, не учитывается вот этот фактор. И второе, это уже следствие, почему мы говорим, если используется раундал, то автоматически мы подозреваем в том, что семена были ГМО содержащие.
Thank you very much for both very, very on-point interventions. Does anyone have any other thoughts about the product labeling and the truth or falseness about the presence of the GMOs in the cereal? Anybody else have any thoughts about why or why not this is something relating to the environment? No? Okay. Then I will just to sum up. So I agree with the interventions made. First off, so it's true that you can't bring any lawsuit whatsoever using the Aarhus Convention. The Aarhus Convention does have its limits. Article 9.3 of the convention provides for standing for acts and omissions, decisions, acts and omissions that may potentially contravene national laws relating to the environment. So this is a limitation in this provision. So you have to have a contravention of national law relating to the environment. And so you have to ask yourself, okay, is product labeling of GMOs national law relating to the environment? And the answer is, I would say absolutely. That generally national laws relating to the environment are very broad. It doesn't have to have the title or say the environment. It can be about taxation, for example. It can be about a very broad number of things. The presence or lack thereof of GMOs and the release and taking it into your body is something that can affect the potential health of soil, water, biodiversity in nature, and have impacts on human health, which all clearly puts it in the realm of the environment. And labeling that informs the consumer as to the potential environmental consequences in the background of the product that they have made, and of how that could affect their own physical well-being and those of their family who are consuming it, does make it, to my mind, very clearly national law relating to the environment. So that element of Article 9.3 is met. And so I hope that I answered the concerns of the judge from Spain. And I hope I also then am coming back to the claim or question posed by Germany is can we assume that there is this environmental activism component in this particular these actions in the press or in social media that were undertaken, and in this lawsuit against the private company for violating the product labeling laws. So I would say yes, there is this environmental aspect. So, for example, in their lawsuit, they are bringing a case for what, in their view, maybe it's unfounded, but in their view, for a violation of product labeling requirements relating to GMOs, which is a potential contravention of national laws relating to the environment. And if I don't want to put you on the spot, you can say no, but because you asked that question, I'm wondering whether given my answer is yes, environmental activism is at issue here. Does that trigger anything in your mind? Does that affect your analysis about this countersuit? If you're willing to jump in.
Was the thought, I seem to remember that there was something in our convention here about protecting people who are doing environmental activism against pursuit and damage, and that would maybe fall under it.
Excellent. Excellent. I think your question was helpful. It also let me clarify something about the scope of Article 9.3 and the need for contravention of environmental national law relating to the environment. And your question is on point for wondering, well, okay, what about this countersuit? So did anyone get that? She suggested that there is a provision in the convention that is supposed to protect people who are engaging in environmental activism. Does anyone disagree, or would anyone like to build on that? Please.
Maybe it's the Article 9.5 of the convention saying that you'd have to remove or reduce financial or other barriers to access to justice.
That's an interesting point. I'm glad you raised that. That is a good point. Anything else? Any other ideas? Please, Antje.
I would assume that it's only defamation if it has actually been proven wrong. Because if there is wheat in there, then it's clearly not defamation, but true. And if there's a damage to the reputation, then that's caused by the company and not by the NGO. However, also the sum that they want to have. I can't even think of any NGO that has that much money, let alone to pay for a case like this. So I think this is also a number that is so clearly over the top that it is meant to intimidate NGOs and civil society.
Okay, all really, I think we're going in the right direction. I like the point about Article 9.5. It is true. Article 9.5 of the convention, I wasn't thinking about it. It requires the parties to, among other things, prepare for to remove barriers, cost barriers in environmental litigation, provide for legal aid and things like this. I think that is relevant, but there is one which I think the others are getting narrowing down on, which is specifically about environmental defenders, and that's Article 3.8 of the Convention, which prohibits the penalization, persecution, and harassment of anyone seeking to exercise their rights under the Aarhus Convention. And this countersuit looks like it would fall under that provision. Specifically, and it's interesting, would be an interesting question for the court. to know the merits. Well, if the claims are actually correct, that is something that is usually a factor in deciding these defamation cases. So not in all jurisdictions, but in some, if what the person is saying is true, then they can't be sued. But that does not always work in courts, unfortunately. But this particular kind of lawsuit is, I would say, has the hallmarks of a strategic lawsuit against public participation, which is called slaps sometimes. And slaps are made with the purpose of silencing critical voices by civil society. They are usually meritless. But their intention is not to win the case, because often they don't have merit. Maybe there are GMOs in this cereal. We don't know. But the timing of this countersuit, which came in response to the publicity campaign and the lawsuit, is suggestive that it might be a strategic lawsuit against public participation. But as Antje pointed out, the 10 million in damages is a very, very high amount of money. And that is also one of the things you look for if you want to see this might be a strategic lawsuit against public participation. I know I'm running out of time, but I'm finishing up. It's okay. All right. So that's what this looks like, and keep in mind, I think as Germany was sort of suggesting, and as the others were suggesting, it could be that that this Justice for the Environment is engaging in something very, very important, providing an important public service by whistleblowing, by bringing to the public's attention something that could be of concern to them and addressing in court what could be a real violation of national laws relating to the environment. Again, this would likely fall under Article 3.8 of the Convention, which prohibits penalization, persecution, and harassment for people exercising their Aarhus rights. And in this case, they were, because they were both because they were bringing a lawsuit under Article 9.3 for this potential contravention of national laws regarding product labeling for GMOs. And also the, just to make clear, the publicity campaign itself, these sort of actions also fall under exercise of Aarhus rights. Article 1 of the Convention makes clear that all of these rights under the Convention are to ensure the health and well-being of present and future generations. And things like exercising free speech rights, journalism, demonstrating, and things like this are also things that should fall under the Convention. Also, requests for environmental information. So if the organization had been asking for information about the presence of GMOs in the cereal, that would also be an exercise of Aarhus rights. If the ENGO was engaged in, there was a regulatory process under which a regulator had to issue a permit for the placing on the market, and it was an Article 6 decision, that would also be an exercise of their rights under the Convention. So I just want to say Article 3.8 is a cross-cutting requirement that covers all parts of the Convention, and it seems to be implicated here. So that is something a court would have to look at and consider, and hopefully legislation is being developed which will assist courts in identifying potentially problematic cases like this, where the exercise of Aarhus rights are being damaged. I see a skeptical face, so I welcome any questions or comments about that, please. You don't have to, but you are most welcome if people have concerns or questions. Okay. If not, because we are out of time, I will move on to my final slide and maybe then just open up the floor for if there are any further questions. So I just wanted to leave you all with a few takeaways. When we're talking about access to justice rights under the convention, generally there are broad rights as to who has standing. That means who has the key to enter the door of a court, but they are differentiated. So we saw, for example, under Article 9.1, that everyone whose request for environmental information was denied in part or in full or otherwise handled improperly, they have standing requirements under Article 9.2 and 3 of the convention are different and more restrictive. We also saw a little bit more about what can be challenged. So again, full or partial rejection of environmental information requests or mishandling. And we saw that for both Article 9.2 concerning projects that might harm the environment and for Article 9.3 regarding plans and programs and policies, that both the substantive legality can be challenged. So, the substantive legality can be challenged, saying that the decision that was taken was simply unlawful, it violates the laws. But you can also challenge the procedural legality. So something like your access to information rights or your public participation rights to make comments, receive information, and things like this were not respected. And that furthermore, contraventions of laws relating to the environment can also be challenged, specifically under Article 9.3. We also examined to some extent how, so what modalities are permitted under the Aarhus Convention. And there we saw, for example, that administrative review is an absolutely accepted modality for the parties under the Aarhus Convention. And in some instances, it may indeed be preferable to having court review, but you need things like binding decisions. So what modalities are not? Again, no binding decisions. You cannot have, you cannot end with a process in which either an administrative body or a court has no power to order the public authority to release the environmental information. And there are prohibitions against prohibitively expensive procedures. So very, very costly procedures are not allowed under the Aarhus Convention, and very, very lengthy procedures. So 8 years to have the resolution in as regards to the rejection of an environmental information request is simply not okay. And then we looked outside of the direct access to justice provisions and looked as well at Article 3.9 of the Convention, addressing this very important element of the transboundary element, that there may be rights, either information or public participation or access to justice in the transboundary context. And I think that is extremely valuable for the purposes of GMOs and LMOs, given the concerns about how they can spread and what transboundary effects we may be dealing with. And we also looked at Article 3.8 of the Convention and the potential for penalization, persecution, and harassment, which is prohibited when someone is exercising their rights under the Convention. And here we looked at exercising their access to justice rights. They cannot be penalized, persecuted, or harassed. And indeed, the case I gave you where the cereal company was countersuing for defamation and reputational damages, I think is a very likely one in practice. Things like that will happen all the time. And I think we will see increasingly that happening in multiple jurisdictions, especially as regards GMOs and LMOs. So with that, next slide. I want to thank you all for your kind, attentive listening, even though it's been 2 very long days and we're all probably very tired. I know I am. But thank you. You participated very actively. You've been a wonderful group. And so thank you very much for that. If you have any questions, wonderful. Otherwise, we can move on.
Thank you very much, Summer, and thank you very much to all of you, because I'm really impressed. I did not recognize that you or anyone in the room is tired. It felt like being very, very active. As you say, we are having 2 very intensive days, but I think this training session under your guidance and with your participation was and is a full success. I learned a lot, not being very much into the issue of access to justice. This was a very informative learning session also for me, and I guess for all of you in one way or the other, but of course you also intervened and shared your experience in this subject. I think it's very important that at the occasion of this global roundtable, we took the effort to dive into the access to justice field more deeper than we have done in the past. So this is inspiring. It probably means that there would be some interesting follow-up activity also in the future. I thank you very much for your able guidance and for your very concrete questions, reflections, and also input. Very good. Yeah. Dear colleagues, let us move on. We have still interesting work ahead of us in these last 2 hours of the roundtable. And the next session is particularly interesting because we are now moving to the reports by our rapporteurs. I kindly ask all the 4 rapporteurs to join me and us here on the podium. And as I had mentioned yesterday and today, this is Angela Lozan, Republic of Moldova, Rapporteur for the Access to Information session. Then Hatem Ben Belgasem, Tunisia, Rapporteur for Public Awareness and Education. Then Maria Ruohonen Lerner, Finland, on public participation. And Faustino Gudin from Spain, access to justice. Of course, this is particularly challenging because this session has just finished and you as rapporteur are now already requested to provide your report. So challenge to all of us, but particularly for you reporting on the last session. Good. I'm very much looking forward to these reports now because I'm sure that our 4 rapporteurs have carefully listened, have summarized what you have heard, and will now share with us the summary of their reflections. I suggest that we hear all 4 reports now in a sequence. If you have any questions or reflections on these reports, I suggest that you remember them and take them to the next session in the course of this afternoon, which will be on the way forward. And I'm sure that some of the summary reports we are now going to hear will inspire you on some suggestions on an appropriate way forward. I know that all 4 rapporteurs probably have provided some substantial texts, longer texts, reflecting all what has been discussed. And these texts will be submitted to the secretariats for including them in the report of this roundtable to be compiled at a later stage, and then of course also circulated and made available on the website. I still suggest that you are not reading out all the text which you have been providing, but take the most relevant points in your reports now to us. I think that will be very good also with respect to being focused and succinct, and also by summarizing the main points. But don't worry, the longer reports will go into the report of the meeting. That means that I kindly invite rapporteurs to restrict yourselves to maximum 10 minutes, maybe even 5 minutes, because 4 times 5 minutes is already 20 minutes, 4 times 10 minutes is 40 minutes, so we have to be aware of that. This is just an invitation to you. I will somehow monitor the time and make myself visible if I think that it's going to be too long. Now, with this introduction from my side, I kindly invite Angela Lausanne, Republic of Moldova, to briefly summarize to us the session which took place yesterday morning, wasn't it? Access to information. Angela, please, you have the floor.
Thank you very much, Mr. President, Mr. Chair. Please don't hesitate to stop me if I will be too long. It is my pleasure and my honor to present the distinguished delegates from 2 countries and 1 international organization that have been presented their contribution to the roundtable of the joint meeting of Aarhus Convention and Cartagena Protocol on biosafety of the Convention on Biological Diversity. And I would like to mention Lulu Augustina, Senior Policy Analyst for Biosafety and Biodiversity Conservation, Ministry of Environment and Forestry of Indonesia, Mr. Mario João de Oliveira, Legal Advisor to the Ministry of Environment and Biodiversity of Guinea-Bissau, and Mrs. Alessandra Salamini, CropLife International. I will start with the presentation with a very short summary of what was presented by 2 national countries that have some joint elements for establishing national biosafety framework in their countries with the support of the UNEP, GEF, NBFI project. And it is very remarkable that their institutional setting had been approved and in place. They have a National Biosafety Committee that is an interdepartmental body which involve several ministries, several sectorial ministries, also academia sector, non-governmental sector. That is quite a good start point for ensuring access to the information, and this is provided by different governmental bodies as well as academia and non-governmental sector. The countries have already established in the country's national biosafety clearinghouse mechanism that is as well apply for the public and involve public to decision making and to participation to the decision making related to living modified organism. And it is a very nice framework to start this communication between the government and public, large public, and different groups of public. At the same time, I would like to say that probably we can mention that not enough capacities in two specific countries have been developed for access to information. And there is a lot of new initiatives and new activities have to be established and provided in the close future. I would say that, for example, in Indonesia, public participation to decision making is in place and imply 60 days publication of a summary for risk assessment before decision making, before the meeting of the National Biosafety Committee that would involve feedbacks from public, and the public opinion and public comments are taken into consideration by the National Biosafety Committee in their decision. The national BCH portal is linked with the central portal of the Cartagena Protocol BCH. That is a very good element, and as well as we have to mention that national BCH is developed in the national languages. That is very appropriate, and can provide with the information of different categories of public, including indigenous people, local communities, and public with limited internet accession, as it was mentioned. At the same time, a number of very good experiences and practices are in place, and specifically use of various festivals or events that organized by national local authorities, including for farmers, for local people, for indigenous people. That is as well very excellent practice and good practices that have to be disseminated and replicated for other countries. It was mentioned that Indonesia is part of Asian biosafety family, the network for a number of Asian countries that bring together their experience. They have the mechanism for exchanging of information, various types of meetings and communications. That is an excellent idea, an excellent practice to develop this communication, biosafety communication in the region, and to learn from the experience of other countries in the region. And the Guinea-Bissau shared their experience to be part of North-South and South-South cooperation programs in the African countries, with the African countries. That would be again replicated and extended. Crop International, Global International Coalition, Crop Life International, as well as presenting us an excellent experience and very useful information pool for biosafety that they promote and develop. For example, it was mentioned that the publicity, peer reviews, public consultation ensure transparency, integrity, and effectiveness of decision making, and as well as information understanding, intellectual property rights, addressing both to Aarhus Convention and to the Cartagena Protocol on biosafety objectives. The global coalition also ensure publicity accessible database, such as for risk assessment, for example, biotrade status that is interoperable with the biosafety clearinghouse mechanism, detection method.com, and crop composition database, cromcomposition.org. The coalition also have a number of filials in different regions and different countries, and they provide this very useful information on biosafety and disseminate information in national languages and using national traditional methods of dissemination and trainings and so on. So this would be, again, very appreciated and very important contribution to public access to the biosafety information. And it can be accessible for many countries in many regions, and making available and understandable the information. The excellence through stewardships also provide principles and management practices the development of different conferences, scientific conferences, participation in a number of global meetings and regional meetings, as well as very much helpful. In the presentation, it was mentioned that the interest of global coalition and private organization to disseminate the new scientific data in an understandable way that is related to DSI, digital sequencing information, as well as synthetic biology. That is absolutely new scientific data that many countries don't have understanding or information of for this. So as the outcome of this information, we may identify main challenges and needs for further developments, and among them we would mention that needs to improve legal system for access to the information, needs for more clarification, debates of scientific knowledge on GMO, needs for public awareness trainings program for specific groups of public, school teachers, students, farmers, journalists, NGOs, lawyers, business association, etc. Needs of educational program for IPLCs for indigenous people and local communications. Needs for more for development of cooperation between Cartagena Protocol and Aarhus Convention. And also maybe more publicity, information flare, video newspapers, and as well a specific point was done to develop regional and international collaboration. For example, Asian Biosafety Family, North-South, South-South collaboration, etc. So this would contribute to transparency of decision-making, to easier dissemination of information for different groups of population, and finally for informed and equitable decision-making on living modified organisms. Thank you.
Thank you, Angela, for this very clear report. Thanks for adequately summarizing this session. And of course, I would like to thank all of you for contributing to a very good discussion during the session on access to information, particularly your reference to the challenges and the way forward, I think are very important for us to take stock and to take as a basis also for our future work. Thank you, Angela. Now, Hatem Ben Belgassem from Tunisia will now summarize to us what was mentioned during the public awareness and education session, maybe also mainly reflecting on challenges and way forward which came up during the discussion. Hatem, you have the floor.
Okay, thank you, Mr. Chair, for giving me the floor. It's a great pleasure for me to be a reporter of this important session in relation with public awareness. I have the chance before to present our experience in this term and during the previous roundtable, and now I will ensure the role of reporter. So our session was opening by a brief introduction to provision on public awareness and education of the Aarhus Convention and the Cartagena Protocol on Biosafety by the two secretariats. We noted that promoting environmental education and encourage widespread public awareness and participation in decision were recalled in the two presentations based of the legal aspect, which is the text of the Aarhus Convention, mainly paragraph 3 of the Article 3, and the Cartagena Protocol on Biosafety, mainly the Article 23. Also, we can note that there is some interest statistic. For example, around 45 to 47 of party have in place a national communication strategy and awareness program on biosafety, and 51% of party have from 1 to 4 academic institutions with training courses and program related to biosafety. And if I refer to the recommendation of our previous roundtable, I think it was also a result of our recommendation, as we emphasize the important to include that, this aspect. And if I see this indicator has increased, and it is very important to put and to reflect the effort done during the previous roundtable. There is another important indicator also, which is the biosafety training materials and online model, which is available and accessible to public. And we know that more than 30% of party which ratified the Cartagena Protocol have at least from 1 to 4 materials or modules. And this number has significant progress. So let's move now to the good practices raised in panel presentation that was ensured by the representative of the Ministry of Environment, Protection and Agriculture of Georgia, Mrs. Nino, followed by the representative of the National Biosafety Authority of Kenya, Mr. Roy, followed by the 2 young representatives of the IB High School Eco Team in Armenia and the Center for Public Awareness and Monitoring. What we can note during this session is that a robust existing national legislative framework regarding biosafety, regulation on many aspects, for example, contained use, export, import, transit, environmental release, labeling, also awareness, raising legal tools and educational on LMOs that promote public awareness and education on biosafety. And we can act this as a good practices example. Here, I talk about the 2 presentations by Kenya and Georgia. So I will make summarize to emphasize the good practices. Also, in parallel to setting in place this legal framework, we can note a very good initiative that was presented to build capacity to raise education and awareness. This good practices was the use of varied methods to share and disseminate these support tools for relevant school, student, teacher, and all interested public party. The dissemination was through book, e-material, chart, school, lecture, seminar, training, workshop, and etc. Also, planning environmental and agriculture education in primary and secondary school for student and teacher is considered as a very good activity in order to enhance the capacity of all this public and their knowledge, improve their knowledge in terms of biosafety issue. Building capacity and building human resource and institutional capacity was also a very good practices by online training courses, educational program, lecture, seminar. That is also a very interesting activity. Developing different comic in food labeling was also very good, as not only teenager or young, but also adult, as me, for example, follow some time, not some time, usually comic. And I think it is a very good practices to promote public awareness. A cooperation with international organizations to develop customized biosafety by a toolkit is considered also as a very important practices. And we finish by the very interesting practices to find out the level of awareness of GMO among teenagers, which is statistical survey. This kind of method is very important because it gives the degree of awareness and help to address the challenge after. As I told now of challenge, let's move to the part regarding challenge and needs. The first issue is the limited resources, human, financial, and infrastructure. Also, despite the development of legislation on public awareness and access with regard to LMOs, concern was expressed over the fact that the level of practical implementation and effective enforcement of such legislation remained low in many countries, and that is, those may be including my country. Public engagement in the technical subject matter, such as modern technology, requires stratification of the public in terms of their information needs and desired level of engagement. Also, the limited interest of teenagers in the GMO topic and the lack of their engagement in discussion and this sentence can be explained by the lack of perceived need for information on GMO. And it was reflected by our young colleague from NGO of Armenia. Sometimes we can find not adequate understandable information on label and the lack of knowledge and awareness regarding LMOs. So that is the different challenge. And to address those challenges, not only at the national, but also at the international level, more efforts are needed in terms of biosafety education. And we can propose the exchange of good practices in order to ensure an active cooperation between international treaties, the combination of modern communication tools, which can greatly facilitate the public awareness, and not only the public awareness, but also the decision making. And we can find this relation maybe for the next session. Public authority should develop communication strategy for different target group and communication. Also, we may to exchange through the two biosafety clearinghouse and ARIUS some case studies or best practices and lesson learned in promoting public awareness and education. And maybe it will be very useful, for example, for the case of Guinea-Bissau that I told yesterday. And the effective collaboration with different stakeholders involved on the topic. We have also some 2 or 3 actions that I prefer that I made the link with the goal P3 that was presented yesterday by Wadzi regarding the capacity building action plan 2020-2030, which promote and facilitate public awareness education. For example, integrate biosafety in relevant educational program and establish academic exchange, establish local, national, and international network in order to encourage bilateral and regional cooperation between public authority and NGO, to share cost and to reduce the problem of financial, and provide training on the development and implementation of biosafety public awareness program and training on biosafety communication. By this, I finish my report and thank you for your kind attention. Thank you.
Thank you, Hatem, for your very clear report. Thanks for summarizing adequately and in time. And thanks to all who contributed to this very important session. Now, we have now heard summaries of yesterday. We are now moving to the third report, public participation. Maria Ruohonen-Lerner will summarize what we heard and discussed yesterday, and also to quite a big part today in the morning. Please, you have the floor.
Yes, hello, and thank you, Chair. Hello, all colleagues. It's a pleasure to try to summarize the important discussions that we had under the public participation. Let me start by, of course, thanking the both secretariats who provided us background information on this. Also, of course, the 3 colleagues who presented their views and ideas Jasna Pekusic from Bosnia-Herzegovina, and Mr. Alejandro Espinosa Calderon from Mexico, and Antje Lor from Ecoropa. So many thanks for that. I try to raise the main, let's say, results. Of course, you will, as the chair told you, we are going to see a longer report on what was presented here. But I think that I'll try to move to the main issues. Of course, all of you, or specifically, of course, the country representatives of Bosnia-Herzegovina and Mexico, presented us your legal systems, your frameworks, your approaches to regulation and how you deal with the issues of GMOs in general, and that was very helpful. In addition to that, you also provided us information how public participation is dealt with in your country. A particular novelty, probably for all of us, was what was introduced by Jasna, the e-consultation platform, and I think that was very interesting. It was a possibility for it's a possibility for the citizens and civil society organizations to provide, both get timely information, but also to provide ideas, suggestions, and additional information. So I think that was very interesting for all of us. From Mexico, what we heard was, of course, that you also have different approaches and tools to deal with public participations, different councils and bodies and consultations with these. You have also taken into consideration your indigenous peoples and local communities, and how to deal with particular needs and issues related to these communities and populations. You are working online. The websites are available to everybody, and there are, of course, in addition to this, you use social media research projects. And in addition to that, maybe from Mexico, what I found interesting is that indeed you have a process to deal with socioeconomic issues. It's dealt with at least with a scientific analysis, but also you are providing this information to your indigenous peoples and local communities. And you see, the aim of this is to achieve better decision making. Of course, what we heard from Ecoropa was not a country approach to this, but an NGO approach to public participation. And I think that was also very useful for us and reminded us about many basic important things. One of them particularly opening what is meant with public and how we should look at that from different angles. Of course, and understandingly, Antje raised issues that you would see as an NGO as a challenge in the EU decision making, calling it a systemic challenge, that broad issues that have different types of effects in different parts of Europe are decided on a centralized approach. And also, in addition to that, you told us that there is no commercial cultivation in Aarhus Party countries and no approval of GMO cultivation in the EU for more than 10 years, no decision on that. You also highlighted that the public participation approaches or forms, I think you called it, has changed, but we didn't have any examples from Europe, particularly for those reasons that I just mentioned. We have examples from food and feed, but indeed you saw some concerns and limitations in the fact that also due to the centralized decision-making, especially related to products and cultivation in the EU, the comments are provided to the Commission and to the EFSA, European Food Safety Authority, and it's mainly through written procedures. And then you pointed out that labeling allows individual decisions, but only after approval. Main challenges listed by you. What I found interesting was, of course, that it was raised that it's important to take, even if online is a good approach and it's a system that reaches out for many, we have to also keep in mind that there are parts of in our societies that will not use online systems. And all of you, I think, particularly maybe Jasna raised the fact that how should we still raise public awareness? And also what was raised by Jasna is that how to deal with polarized views of the public. And I think my analysis from what I heard from Mexico is that it is the challenges that you still need is how to reach out to your indigenous peoples and local communities and your Afro-Mexican populations and communities. Okoropa, of course, took a little different approach. Your concerns were related to the Commission's proposal, EU Commission's proposal, how to deal with certain new genomic techniques. Your concerns were raised in relation to the fact that there is a suggestion that some of these applications would not go through risk assessment. There would be no monitoring and labeling on these products, and that would of course lead to a situation where there is no decision making, there is no public participation. I think you all shared, or it was clear to us what would be the benefits for providing effective access. It's of course improvement of public policies, cooperation between government and the governmental institutions and civil society, improve any active participation. Socioeconomic analysis and information is important and will improve decision making. As I already said, modern tools are very welcome. They make public participation easy and accessible. However, there is always the issue of how to reach everybody in the society. Indigenous languages and different groups is of course the concern. Antje mentioned the importance of the BCH and noted that parties are indeed obliged to provide information. You had good ideas how to improve, more education through social networks, workshops, training, raising people's awareness. Especially indigenous peoples and Afro-Mexican peoples and communities were mentioned by our Mexican colleague, materials in indigenous or local languages. To mention a few of the issues you raised. And Ekoropa was of the view that in order to improve public participation, of course, there should be always regulation, because that would allow better decision making and also would allow public participation in a better way than what is suggested now by the Commission. Then I took do I still have a minute? 1 minute, but I'll be very quick. And this was already an achievement for somebody who speaks as much as me. Anyway, further recommendations. I think we still need further improvement on mechanisms and modalities, and online and easy tools to provide comments, but at the same time keeping in mind that everybody should be reached in our different societies, and it's for us to decide how to best do that. In some countries it's local newspapers, in some countries it's radios, it's different tools. You are the best persons to decide on that. And particularly I want to mention again local and indigenous, of course, communities, but of course local languages. And then I want to say at the end that I think that we could see some improvement or some more activities in relation to the Cartagena Protocol and its involvement in public participation. I think now is the time. We have new plans, both the implementation plan and the capacity building action plan. And we also have two targets that are important for biosafety, target 17 and target 22. And we need to make sure that these will also take biosafety issues into consideration. Thank you.
Thank you, Maria, very much for this very clear report. Thanks to all who contributed to a successful session on public participation yesterday evening and this morning. Now, last but not least, I'm giving the floor to Faustino Gudin, who will be so kind to summarize the discussion which we just had on access to justice. Of course, quite a challenge because the session just finished, but I'm sure you will manage. Maximum 10 minutes, please. You have the floor.
Thank you very much, Chair. I'm elated to be here to share with you this amazing experience. First and foremost, it's essential to understand that the three pillars of the system are interconnected. They rely on each other and don't work in isolation. For example, the right to information is ineffective without the right to complain. Without the proper information, decision-making becomes impractical. Similarly, the right to public participation depends on authorities being accountable if they choose not to pay attention to public opinion. Therefore, the coherence of the rights of information and participation in decision-making is compromised without the ability to seek remedies from the independent body, just in case the authority doesn't abide by the rules. However, the third stage is less advanced because it depends on the previous progress made in the first two pillars. So now we are going to case issues arise. The representative of the Aarhus Convention, Marina Janus, highlights issues such as the limited awareness among legal professionals, insufficient standing from environmental NGOs, financial barriers, prolonged court proceedings, inadequate remedies and enforcement difficulties. This includes clarifying legislation, the possibility to disclose information, supporting public interest litigation, and promoting collective redress with a focus on specialization in environmental law and understanding relating risk among legal professionals. The Secretariat of Cartagena Protocol, in her discussion, there was emphasis on the significance of the Target 22 was highlighted, underlining its role in ensuring inclusive access to justice in biodiversity decision-making, particularly for indigenous people and local communities. Guidance provided by COP decision 15/6 and the Annex 1 was mentioned in terms of aligning national biodiversity strategies with GBF, encouraging collaboration with the across the sectors. The European Commission, DG Environment, delves into the legal landscape with the European Court of Justice case C-24/21. The representing of the European Eco Forums and covers challenge in LMO, GMOs regulation, inadequate frameworks, and limited public awareness pose barriers to access to justice. Positive trends include regulatory efforts and increased engagement, with negative aspects involve transparency issues and cross-border complexities. The representative of Biosafety Unit Communication Unit details the nuance of the Articles 23 implementation. Mrs. Summer Kerm, as a facilitator, she adopts an educational approach, providing training on access to justice for LMOs and GMOs across 4 different scenarios. Case studies illustrate procedures addressing concern ranging from NGO release to cross-border transport and local ecological impact. Main challenge and needs, the topic is limited scientific understanding. And the first point is the challenge stakeholders lack of a comprehensive knowledge of the long-term consequences of NGOs. Needs and emphasize clear, summarized in non-technical language for better understanding. Specialize the court to comprehend expert opinions effectively. The second point is regulatory framework challenge cumbersome and clear and adequate regulatory frameworks result in legal uncertainties impeding access to justice. Needs improve clarity and accessibility of regulation for all stakeholders, broaden standing interpretation to include NGOs, ensuring fair representation. Enforcement issues challenge a weak enforcement mechanism to contribute to compliance, challenge creating barriers to justice, needs strengthening enforcement mechanism monitoring for effective compliance, including injunctive reliefs. Increase the substantive review by courts and independent administrative bodies. Insufficient information accessibility, the challenge is low quality and accessible information hampers access to legal resources. Regarding the needs, develop e-justice initiative for better access to understandable legal information and increase specialization of the judiciary in environmental law for deeper understanding. The 5 items is the transparency concerned. The challenge is lack of transparency in LMO, GMOs, regulatory protests create mistrust, obstructing access to justice, and the needs are increased transparency in regulatory protests for trans building. And the second one is raise awareness among legal professionals and the public about environmental law. Then now we are going to deal with another point that is the benefits for providing access to justice, enhance understanding of LMOs, GMOs, and decision-making process, enhance trust and accountability and governance, better implementation and legitimacy of the decision, economic gains and improved sustainability, advancing access to legal information and data dissemination. Access to justice plays a crucial role in safeguarding rights, ensuring environmental accountability, and upholding human rights. It empowers individuals to exercise their rights, challenge discrimination, and hold decision makers accountable for their action. The 7th point is access to justice as a tool for biodiversity conservation and managing risk from GMOs. So in essence, access to justice emerged as a driving force facilitating transparency, public participation, legal certainty, and human rights in the management of the GMOs, in line with the aspiration on the coming Montreal GBF. Good practice share, Armenia and University Institute facilitates a unique public consultation on NGOs, allowing the public to share opinions on the draft law. The initiative aims to gather diverse perspectives on the principle guiding GMO regulation. Georgia and the Aarhus Center of Georgia, operating with a small team and a dedicated lawyer, focus on the access to justice pillar on the Aarhus Convention. The center also conducts regular training sessions, seminars, workshops, and public awareness activities, showcasing effective implementation. Albania mentioned that the administrative courts are available to interest groups in case involving the violation of their legitimate public interest. The majority of the parties, the European Union, Iceland, Norway, Switzerland, and UK use e-justice portal that are very useful. There is some cases from Spain or Portugal that they have a special tools. Suggesting for improvement, the first is harmonize national legal frameworks, propose a measure to strengthen national regulatory frameworks for GMOs, ensuring alignment with international standards such as the Cartagena Protocol, Aarhus Convention, Almaty Amendment, and the Target 22 of the Global Biodiversity Framework. The second is to clarify legislation for Aarhus Convention adherence, advocate for transparent legislation on access to justice, aligning seamlessly with Article 9 of the Aarhus Convention and the Almaty Amendment. The third point is expand public interest litigation scope and introduce reforms in standing, suggest expanding public interest litigation from GMOs under Cartagena Protocol guidelines, Article 23, propose reforms to involve diverse legal actors focusing on NGOs and indigenous people, aligning with Aarhus Convention and Target 22 of the Global Regulatory Framework. This strategy aims for inclusive access to justice and diverse perspective in GMO-related decision-making. The fourth point is to capacity building for judicial specialization, advocate for investing in specialized expertise within the judiciary and administrative bodies from GMOs regulation, involve NGOs to boost their capacity for effective participation in pursuing justice. The fifth point, integrate fundamental right with biodiversity protection, emphasize the integration of the fundamental right to a clean, healthy, and sustainable environmental with the protection of biodiversity in the context of GMOs. This last but not least, the ensuring legal transparency, promote transparency in legal procedures and regulations related to GMOs, implement mechanisms outlined in the Cartagena Protocol, Article 22, to ensure the ability to, of accessible and understandable information. This approach guarantees a more comprehensive access to justice for legal actors mentioned above. Finally, it's important to adopt a measure to discourage the strategic lawsuits against public participation. Finally, is the proposal for the future work in this area at national and international level, enhance legal clarity and compliance, including injunctive reliefs, ensure the clarity of legislation on access to justice, emphasizing compliance with the Aarhus Convention, Article 9, Almaty Amendment, and relevant international standards. Advocates for amendments to national legislation that reinforce access to justice principle in the context of GMOs. The second point is support for public interest litigation, support and encourage the increasing admissibility of public interest litigation and collective redress in cases related to GMOs. Advocate for legal reforms that empowers individuals, NGOs, and communities to bring environmental justice cases to court, aligning with the Cartagena Protocol. Capacity building is the third point for effective judicial process, elevate specialization in environmental law from the judiciary, impartial and administrative bodies, and the legal professional engaged in GMOs cases. Strengthen court capacities in assessing environmental risk, foster collaboration with scientific institutions, and ensure compliance with the Article 9 of the Aarhus Convention and the Almaty Amendment Preamble, Paragraph 6.
Faustino,
Yes, 1 minute, not more. Inclusive multi-stakeholder collaboration for access to justice, foster inclusive dialogues among diverse stakeholders, including government bodies, NGOs, academia, and the private sector to address justice barriers in GMOs-related cases. Strengthening, and the final is to strengthen access to justice through enhanced international cooperation. Improve international cooperation for fair access to justice in GMOs cases. Promote and increase the role of focal and point networks, such as one that exists in the Aarhus Convention, to coordinate efforts and exchange information. Aligned with the Cartagena Protocol, Aarhus Convention, and relevant legal framework, this ensures an united global approach. Focal points make it easier for countries to work together on the access to justice for GMOs. Thank you very much for your attention. That's all.
Thank you very much, Faustino, for a very comprehensive report. Apologies for interrupting. It's always very difficult to ask rapporteurs to be brief. I know, because you have so much to report, and the reason why you have so much to report is because we have had such rich discussions, which is of course very good, and it's really an added value of this roundtable. So apologies, and thanks for restricting for sticking more or less to the time, which is of course very helpful so that we can continue with our work. Now, dear colleagues, and thanks to all 4 rapporteurs for this. Thanks to all of you for providing the substance for these reports. And I'm really impressed what we have achieved and what we have been able to put forward in 2 days here. Very good. I assume that you probably have some further inspiration having listened to these reports. and I suggest that you take them with you in the next session, which will be the last but one session in our roundtable here. But before we move to that session, which will be about the way forward, I think we all deserve a brief break, and that will be a coffee or other refreshment break. Please try to be back at 10 minutes past 5. I know it's short, but we have some work to conclude. So 10 minutes past 5 sharp, we will meet here again and continue. Thank you. Kindly ask for your understanding. Let us continue and let us go through our final rounds at this round table to be able to finish at the latest by 6. We have a little more work to do together. And the next very important point on our agenda is session 8, which is about the way forward. And we will kick this session off by a brief presentation by Maike Salise. You have seen and heard her already a couple of times during this roundtable. She will present to us the results and the outcomes of a survey in which many of you have participated in preparations for this roundtable, and which resulted in a couple of very interesting conclusions, which Maike will present to us. So you have the floor, please.
Thank you very much. So we can already go to the next slide. We disseminated a survey to parties, interested member states and stakeholders on the existing guiding material that exists and questions related to GMOs and LMOs. They're listed here on the page. They're also on the website, the Luca guidelines, a pocket guide, a checklist for key measures for the ratification and implementation of the Aarhus Convention and the Cartagena Protocol, and the Maastricht recommendations. And with the survey, we basically had 3 objectives. One is to better understand how parties to both treaties, interested member states, and different stakeholders have been using this material. Also to raise awareness of its existence, and to collect some examples of how public awareness, education, access to information, public participation, access to justice were promoted by parties to both treaties, interested member states, and stakeholders. And so we asked 12 questions. The survey was open for 43 days, and we received 35 responses. And on the next slide, you see how it was, who responded. So we got 7 and 8 responses from parties. 3 of these responses were parties to both instruments. And then about 1/3 of the answers were from NGO, which is the blue bar here. 1 response from private sector, and then academia and some other respondents like Aarhus centers, judges, and so on. And then we asked what materials were used. And so basically the 4 large parts in orange, yellow, pink, and blue are the 4 guiding materials we've been asking about. And I think it's quite good to see that all 4 of them are used by about 1/4 or 1/5 of the respondents. And the small green percentage is actually where they said they're using all of the material. And only a very small portion, 4.5% of the respondents, said they're not aware of this material. So at least the respondents to the survey are very much aware of the materials that is available, and they're using it. How they're using it was the next question. So if we go to the next slide, we started with the first 20 of them said they read and consulted them for their daily work. So they're using it. Then yellow and green is disseminating these materials within colleagues in the institution. So they're not only reading it, but also sharing it. And the green bar, and these are 15 or 42% of the answers we received is that they actually use this material to develop their own national guidelines adapted to the specific situation. So it provides an input to the preparation of other material. And then the light blue and the dark blue bars show that this material has been disseminated outside the institution. So either shared with other public sector colleagues is light blue, or disseminated to stakeholders. And then there's a sharp decline. So the dark purple one is that the material has been translated into other languages. The pink one is only 3 answers we got, not much used because it's not relevant. Or the light pink, they were not aware. And then there are other ways of using it, and these include publishing it on a website, using it during awareness days and so on. So there are a few specifications of how, in addition to our list, this material has been used. Then on the next slide, these are just a quick overview of in what other national and local languages the material has been translated. Not all of it, but maybe some of it. So Albanian, Arabic, Mongolian, Khmer, Romanian, Nepali, and indigenous languages. So this is in addition to the 3 languages that the secretaries provide: English, French, and Russian. And I think the pocket guide is also translated into Arabic, Chinese, and Spanish. So in all UN official languages. Next slide. So then we asked how have you been using this material in your work? So these are 2 examples of awareness raising by respondents. So they used our material and organized a seminar to present it to lawyers in government agencies. So this was the example of the Maastricht recommendations. So parties organized seminars to raise awareness and explain what the material is all about and what are the key messages in these materials. Or another example is a training course by the ministry that was organized for members on a lab. So a very, I think a good way of making sure that everyone in the public authority is aware of this material. On the next slide, it goes more into using it for your own work or so for example, when implementing provisions of the convention and the protocol at national level, someone else responded saying that this person cited the content when drafting amendments to national legislation. So the material has been useful in that kind of situations as well. And also help to develop own guidelines for the review of a national biodiversity strategy and action plan. And then the next slide is more towards outreach with key target groups. So it has been used and shared with stakeholders, used for educational purposes, for national committees. Also, it's consulted when a party is reaching out to media and journalists, so how on the guidance that this material provides in the work with indigenous peoples and local communities, NGOs. And then there were 2 examples also of where respondents used it in their personal blogs, or they read it out of curiosity, which I also found interesting that the titles is inspiring to actually look into these documents. And so if the responses we got, if someone was not using the material, it's not being aware, being new to the topic, the GMO is not their competence, or they are still studying it or producing completely own material. So for us, it's just an indication that it doesn't seem to be irrelevant what we've been producing. And this slide, I think, is an important one also for the way forward discussion, because we asked, what do you need in addition to this existing material? Do you need it in different formats, or do you need different type of guiding material? So that helps us also as the secretariats to see what can we do next. And so I find it quite interesting that the largest number of responses, I think 18, is we need an online version of the material that is there. So a different way of accessing the information, scrolling through it, maybe linking to other pages or more information, but presenting it in a different format online. The second largest is brochures, and we got the concrete example of the LUCA guidelines to be produced as a brochure. So instead of having the formal documents, add pictures, do a layout version of it so that it's visually more appealing maybe. And the green bar is videos. I think that also links to what we discussed at the previous roundtable, that we might produce a video on the material that is available. And then the last point, or the lowest number of requests, is to have visualizations. But asked about the type of guiding materials, there were some recommendations requests for target group specific materials, and that was mentioned that visual material with quick and general messages can be very useful for the public. So I think there's a link between the visualization and just to simplify messages and make it easy understandable through visualizations. Yeah, I think I stop here. And then the last set of questions we had was about sharing examples of promotion. And so there, if I group the responses we got, there was some regarding outreach to specific target groups, farmers, teachers, journalists, and media. Then different type of material and tools that were developed by respondents. So simplified text with pictures, illustrations, a brochure on the Cartagena Protocol, online guides in also national languages, briefing material, toolkits, websites, and web applications. So especially after COVID, there were some mentioned that they were increasingly focusing on online materials. And then training and events that were conducted, for example, also on special occasions like International Biodiversity Day, to have outreach events there. And then some lessons learned that were indicated by respondents on the next slide. So what respondents found out, and I think it also partially mirrors discussions at the previous roundtable, that the narrative should be focused simply and concrete, but not oversimplified. That information should be balanced and objective, and the public should be provided with accurate and relevant information about GMOs, and that there should be availability for explanations and feedback, so that being approachable after you handed out this information for questions and clarifications, because it's a difficult topic. There was also the note that public administrations have limited resources to promote this topic actively. And again, with a link to the COVID pandemic that we're just coming out of, is that online platforms have been used more, but there's also the important face-to-face interaction, in particular when you're talking to youth as an audience, and that the information should be hands-on, not so theoretical, because that produces the best results. Thank you very much.
Thank you very much, Maike, for this very clear presentation. And I really particularly would like to thank the secretariats for the efforts of arranging such a questionnaire and for organizing such a survey in preparation for this roundtable. I think this is an extremely relevant instrument, and it allows us to go into our discussions on the way forward in a much better prepared way. And just briefly reflecting on what I've heard now in your summary, it clearly shows how important products we are developing, which are making a difference outside, which are providing added value, which are used, be it the pocket guide, the checklist, the Luca guidelines, etc. So that's really impressive, and it shows that this roundtable, our discussions really have an impact, which is very good. That should stimulate us to be able to continue and to always see how we can even further improve the way we are doing and what we are doing. Now, dear colleagues, in this brief round now, which I would like you to invite you to engage, I would just like to see if there are any questions or reflections with respect to this survey, which you just have seen. Maybe you would like to add some considerations here from your experience. On the way forward, I particularly would like to invite you to share with us if you have any recommendations on national or regional collaboration, recommendations to the two secretariats on the way how they are collaborating, recommendations for you in your countries and your constituencies, what your national plans and guidelines should endeavor to achieve. And of course, also, if you have any feedback to this joint roundtable here, do you find it particularly useful? Do you have suggestions for further improvements? What could future activities try to embrace? Should the format of this roundtable be kept as it has been used, for example, today and yesterday? Do you regard this as appropriate to have proposals for different formats? And what issues you would like to address in the future? The survey and the results of the survey already implied some of the future issues. Of course, please also consult your learning journal if you have used it. I mentioned in the beginning that this is an instrument for you. Maybe you have been taking notes, and maybe if you would like, just share what you have noted down with us. Completely voluntary. It's your personal learning journal, of course, but maybe you would like to share something with us here. Now the floor is open for recommendations, observations, and further inputs from your side. It's towards the end of this roundtable, your additional opportunity to raise your voice. Who would like to start? Who has any comments? And I know it's always a bit difficult after so much information, after 2 long days, after inspiring but also a bit exhaustive exercises to again come up with energetic interventions. But I see that with my few words, I have inspired some colleagues to come in. And I start with Ecoforum, Ilya, and then followed by Mexico, please.
I want to stress that in my view, during very long time when this issue is discussing, the issue of financing of public participation, and especially access to information and access to justice, especially in this substantially technical issue, remains the most important. Why? We do not know what is happening. In fact, we are following different laws, regulations, etc. But in decision-making, situation is similar. Public do not have access or even any information about what is happening in field, but we are following only official reports, which are usually far from reality. And when we want to come to the court, again, we have to have clear data in hands concerning crops, concerning products, because finally, in our countries, many products contain and many seeds in to be sold contained in reality GMOs. But public do not know about and could not fight with that. I don't know what to do with that because now we have a world economic crisis, and I'm not sure that we will go forward too much with that. But without solution of these issues, we could not go forward for sure. In my view, this is main obstacle with which we have fight or which we have solved. We learned a lot during these 2 days. I'm very much happy that in the third world, which we could say many countries are going forward despite of all difficulties. For example, I was very much impressed by a situation in Indonesia. Bravo. Something 15 years ago, I participated in the similar workshop, mostly dedicated to methodologies in Tunisia. It's very much impressed me too that these countries are going. It was organized by European Union, but anyway, very much information, and we see that national authorities try to do the best. The other thing that because of many difficulties, it is not happening sometime. So in my view, we need to go forward with these efforts of information, of involvement of public into decision making, but the main obstacles I said about. It's no practical laboratories, very expensive analysis, which does not permit us to give to have a picture what is happening in reality. So, in my view, this movement should be go on. When I mean Moldova, in 2005, proposed this amendment, we did not thought that, together with NGOs, we did not thought that the coming into force will be so long, which is not good. And plus to that, the major part of countries who fight it for that amendment, unfortunately now could not ratify it. My invitation for these countries to solve this very simple issue, because in reality, it does not cost money, and but it will permit the whole community, Aarhus community, to go forward with this issue. Thank you.
Thank you very much, Ilya, Ecoforum, for your supportive words and also for your words of consideration. Now, Mexico is next, followed by Armenia and then Germany. Mexico, please.
Thanks a lot. I think that one very important point for the protocol Cartagena is to give more information to the people in the different countries, because the people need to know the importance of the effect of GMOs. For example, in Mexico, we have 68 languages. Indigenous language. I think it's very important that the people knows the effects of GMOs. Protocol Cartagena could give a very good elements for the people. Yeah.
Thank you, Mexico. Very wise and pertinent words, which we will take into account. Now, next is Armenia, followed by Germany. Armenia, please, you have the floor.
Thank you. At first, I would like to thank you to Secretariat for the questionnaire and references to the materials that are very useful for us and for interesting questions to thought about them. Secondly, it is very important the experience of education materials. For example, experience of Georgia, we already have discussed if we can do some exchange of these materials translated into Armenian. And if there are any materials in other that have other parties, would appreciate if Secretariat could share with us. And also we are interested in collaboration of authorities body with the private laboratories. If any party has such experience, we would appreciate again to get this information. Thank you.
Thank you very much, Armenia. Very important points you are raising. Thank you. Germany, please.
Yes, thank you. My comment is related really to what Ilya said about financing and also to what Alejandro said about information to people in different countries. I was wondering, there has been an increase in information provision and participatory events that are not organized by authorities in their own countries, but are outreach activities that can be, for example, from organizations with philanthropic financing or with corporate financing, and that then reach out to indigenous and local communities in other countries. And together with the financing question, this brings up some problems around who provides what information, given that there is not always consensus on the information that would be correct, and that there are also different approaches to how participation is legitimately facilitated. So I think that is a point that I would like to see.
Thank you. Germany, very important point, relates to the adequacy and also the reliability of information. How can that be taken into account? Dear colleagues, are there further requests for the floor? Who would like to come in finally? You can put down your flags so that I can keep track. Yes, please.
Consider important is to stress the importance of this meeting, because the vulnerability of the society has not is defenseless against these GMOs. So if we don't get information, if this information don't go to the decision-making process, and the courts don't know anything about it, we are eating something that we don't know what is. So it's important not only for the human health. You know, the ecosystem are very sensitive. It's very problematic, this topic. For me, I really now I am really involved in this topic, and I think like environmental judge, that is something that is going to be crucial in the future. So I only want to make this remark. Thank you very much for it.
Thank you, Faustino. It is indeed a very important remark. Information as the basis for all subsequent issues, such as participation and access to justice, information to the courts, and all those who are involved in this subject. Yes, Sama, please.
Very briefly, this is something that actually could be have a session on this at one of the judicial colloquia. That is an opportunity where judges come. It's held back to back with the task force on access to justice, and if you sort of in your position as a judge, I mean, I agree that it will be critical that courts understand the nature of potential GMO cases that come in front of them. So that is something perhaps for the Secretariat to do a polling, but perhaps a session devoted specifically to GMOs would be relevant in that context.
Thank you, Sama. Very good idea. The Secretariat will reflect and explore how to make that a reality in the future. Is there any further request for the floor? Because if that is not the case, I would like to thank you for your suggestions now also in this round on way forward. Of course, knowing that previous sessions in these 2 days have already provided some input for a way forward and for the future, but we are now could collect some more ideas from your side after having heard also the results of the survey. Good, dear colleagues, that gives me the possibility to make an attempt in the final session of this roundtable today. And yesterday and today, to come to a close of this roundtable by sharing with you some points which I would like to put together in a chair summary of this very productive roundtable which we have had together. Already yesterday evening, I was reflecting a lot on the sessions which we had yesterday, and the preliminary results, and also today again was very rich. And of course, I will also now try to make an attempt to take into account in my summary some points which have been raised just in the last minutes or hours, but maybe you can also bear with us. We may reflect and put something into the summary also subsequent to this meeting and upon further reflection. And with the excellent help and assistance by the two secretariats, for which I'm very grateful, and I thank to the colleagues from the UNECE, our secretariat, and the CPD secretariat, the Cartagena Protocol secretariat, for all their work in putting together the background information and all the organization of this roundtable, but also now in assisting me in providing a brief summary to you on what this roundtable has produced, what you have put forward. Colleagues, in addition to the major outcomes already presented by the rapporteurs, and remember, just an hour ago, we had very concrete summary reports from 4 rapporteurs, and I don't want to repeat what our able colleagues have already said. But still, I would like to outline towards the end of this roundtable a few points that I have observed and that could also be taken into account for the future work. Of course, the meeting will result in a meeting report, as always, and it will be a very comprehensive report prepared jointly by the two secretariats in consultation with me. And this will incorporate also the chair's summary. In the interest of, and it's going to be a rather comprehensive summary because you have been so productive and given me so much thought to be taken into account. But in the interest of time, I hope you allow me that I will not mention all points now, but a more comprehensive summary will be prepared in a written format and also distributed to you along with the group photo, the family photo, which we have taken yesterday. You may remember, it seems like quite some time ago, but yesterday lunchtime, we took a very nice group photo, family photo, if we may call it. And this will be sent to you soon after this meeting. It will be an unedited version of the chair's summary. The editors will still go through it and it will then be incorporated in the report, but you will receive it very soon so that you also have something in your hands as a result of this meeting. Now, colleagues, as I said, and not presenting to you the complete picture now, I would like to point out some general observations which go through my head when I reflect on those 2 days. And this is, first of all, that the cooperation between government institutions on the one hand and civil society is the fundamental value of democratic societies. I think we have to remember that all the time. And it should be promoted also in LMO and GMO matters. That, I think, is very important. I also think, and that's also a general observation, that it is important to promote the important role that environmental defenders and also environmental human rights defenders, there are different terms used by, but very, of course, synergetic terms used by the two instruments, play in these LMO, GMO related matters and ensure that their protection is in line with the Aarhus Convention and also in line with the Target 22 of the Global Biodiversity Framework. I also think that, of course, we again have recognized that LMO, GMO issues are quite complex. They involve a lot of different scientific, technical, but also societal issues, and therefore cooperation between relevant public authorities, such as those responsible for food safety, for environmental safety, veterinary issues, health, trade, economy, and you name it, and law enforcement institutions shall be promoted. It's very important, this kind of collaboration. Also, this final discussion among you now on the way forward showed that it is so important to allocate required human and financial resources for GMO, LMO related work on all different areas, including establishing detection and identification laboratories as appropriate. We heard it again and again that it's so important also to have these facilities in place, to have analytical possibilities to detect, to ensure traceability. I think it's also, as a general observation, I would like to share with you that it became clear that it is important to continue what we have already been doing, what we have also been doing today, and that is to support training sessions and awareness-raising events on the obligations of the two legal instruments, Aarhus Convention and Cartagena Protocol. This should be continued and involve officials of public authorities, municipalities, but also members of the jurisdiction, the private sector, the developers, the industry, journalists, and of course, non-governmental organizations. As I've said, our 4 rapporteurs have very adequately summarized the discussions on access to justice and all the other sessions, but still allow me to reflect on a few issues on all these sessions as well from my side. Regarding access to information, I think it's very clear that effective provision of information is a precondition. It's crucial. It's a precondition for meaningful public participation and successful access to justice. So access to information is the basis for everything else. And it became also clear during this roundtable that only limited grounds to refuse this information shall be applied. This shall be interpreted in a restrictive way, and public interest served by disclosure should always be taken into account. I think we also addressed new developments, new technical developments, and I would like to stress that it is also important to continue providing information with regard to new genomic techniques as it becomes more available. This is an important subject. Also synthetic biology and other new topics. We observe the current trend of digitalization, which is also so relevant for access to information. And we should put particular emphasis on that. For example, by promoting the integration of LMOs and GMO-related websites and databases into a nationwide digital information system where that can be the case. Also, translation into national and regional languages for GMO-related matters is so important. People need to get the information and the understanding, and the appropriate language is an important precondition for that. Regarding public awareness and education, we have heard a lot of good practice examples with teachers, with comics, with instruments to make the information more digestible, more available also to the broad general public and the interested public without oversimplifying, but presenting it in a way so that it can be understood. Target group specific education and training programs could be appropriate for that purpose. In addition to the general public, maybe also to address specifically legal experts, judges, farmers, manufacturers, teachers. We have heard so much about teachers and their way of promoting understanding. Information tools such as labeling, and we have examples also in other areas such as eco-labeling, food labeling should be used for that purpose. Labeling is an information instrument. Toolkits to be prepared, to be customized for different social and cultural backgrounds could be also an appropriate way forward. And I think we also found out that it's so important also to address children and the youth. We have had so much, so nice and inspiring input from youth colleagues. Indigenous peoples and local communities, farmers, women and youth are very important target groups. Public participation in decision-making has accompanied us through all the roundtables in the past and also today. And it again became clear that to promote inclusion of a wide range of interested stakeholders, and again, I'm not naming all of them, we are familiar with the relevant stakeholders here, also for public participation, will continue to be important. The work of the national advisory bodies is important for that purpose as well. The biosafety committees, the councils, etc. We also identified that there could be potential conflicts of interest, and we have to make them transparent, and we have to deal with them, not to ignore. Labeling and cultivation registers could be important also for public participation purposes. And we also recognize that public participation depends on the legal requirement for a process whereby products or certain GMOs are really falling under legislation. So it is important not to exclude any types of GMOs from the definition of GMOs, otherwise they won't be regulated, and otherwise there will also not be a possibility for public participation. We have to be clear about that. Of course, we also heard about modern and more interactive tools of public participation. It need not necessarily be only public meetings. It can be online tools. We are getting more and more familiar with that, but the face-to-face situation continues to be important, I think. We heard. Access to justice, again, very important that we addressed it in such a detailed manner here during this meeting, and continue strengthening the specialization of the judiciary, other independent review bodies, legal professionals and professionals in environmental law is so important to allow access to justice to be taken more into account than it has been so far. And these the two instruments, the Aarhus Convention and the CBD with the Target 22, provide a lot of opportunity for that purpose. It is important to ensure the clarity of legislation on access to justice and also on the enforcement measures. It is important to improve the capacity of courts and other relevant bodies in using knowledge about environmental risks, and independent environmental expertise is necessary for that purpose. International collaboration on access to justice should continue, as it has been the case here. And implement requirements of access to justice in line with the Aarhus Convention and in line with the Global Biodiversity Framework should be a future challenge to all of us. My final remarks for actions at the national level would include, and you have made suggestions here, to continue strengthening the coordination also at the national level between the focal points of the respective instruments and treaties. I think it already works quite nicely in many countries. It could be even further developed. And we have heard examples here. The Asia Biosafety Clearinghouse family is such a nice example where this collaboration already takes place. Parties to the Aarhus Convention, of course, we continue our plea to implement the Aarhus Convention in the context of the GMOs and ratify and implement the GMO amendment to the Aarhus Convention. Only one more ratification needed for its entry into force. Parties to the Cartagena Protocol, of course, you are encouraged to set in practice the implementation plan as agreed and as adopted at COP10, and also to work towards achieving targets 17 and 22, which have been addressed also during this roundtable here. At the multilateral level, continue to collaborate between the two secretariats and among all of us also at the multilateral level. Continue develop guidance materials as we have already in our hands. These successful products such as Pocket Guide, etc., should be further developed and maybe also made available in a more appropriate format, visualized videos, etc. There is a lot of possibility to further improve it. Organizing, well, about the format, organizing a similar roundtable like this one here yesterday and today in the next intersessional period of the two treaties could be a very nice opportunity, and I heard a lot of support for that. This because it allows parties to both instruments from different regions, we have seen it here, to exchange experiences and support implementation of the Aarhus Convention and of the Cartagena Protocol in synergy. We should also consider the possibility of engaging other relevant international treaties for that purpose, for example, the Escazú Agreement and other programs and instruments. I would also suggest that we call on parties to the Aarhus Convention and the Cartagena Protocol and other interested member states to provide funds for that purpose, for the organization of the next roundtable, for the organization of further collaboration. It is so important to ensure a wide geographic representation coming from different regions, and I'm so happy that it worked well for this roundtable. Now, as I said, the key outcomes of this roundtable will be reported. A report will be put together and sent to you and made available. It will be reported to the 28th meeting of the working group of the parties to the Aarhus Convention that will take place here in Geneva next July 2024. And it will also be submitted to the 8th meeting of the parties to the Aarhus Convention in 2025. And it will be also shared with the 11th meeting of the Conference of the Parties, serving as the meeting of the parties to the Cartagena Protocol, which is scheduled for next autumn, October 2024. So what we have been producing here is relevant, has an impact. It's going to be reported to the main governing bodies of the two treaties. A thematic session on the topic is also planned at the 29th meeting of the working group of the parties to the Aarhus Convention, also in the year 2025. Let me conclude by reminding us all that today's event, yesterday's and today's event, also assisted parties to both treaties and interested member states to further their other international commitments related to transparency, to the rule of law and participation in GMO and LMO related matters, and in particular with respect to the Sustainable Development Goals, the SDGs. We have heard it, SDG 2, Zero Hunger, SDG 15, Life on Land, SDG 16, Responsive, Inclusive, Participatory and Representative Decision-Making are very important SDGs of relevance to what we have been discussing here. And of course, we tackle together, hopefully, the triple crisis with regard to biodiversity loss, climate change, and also the resource crisis and other relevant issues. Colleagues, I would like to conclude by thanking very much you as delegates, as colleagues, as friends to this meeting for coming here, for being so active, for providing your experience, for sharing it with us, for entering very actively into a discussion. I think this was a very lively exercise, and that was meant for, and thanks to you. I would also like to thank all the panelists and presenters for your preparations. The PowerPoint slides will also be shared with you in addition to the report. I, of course, would like to thank my colleagues at the two secretariats once again for their excellent work. This is the basis for all what we are doing here. Thanks to the UNEC Aarhus Convention Secretariat, thanks to the CBD Secretariat. You are marvelous and you are assisting us really in an excellent manner. I would also like to thank very much our interpreters for the tough work. You have been facilitating a lot our discussion, and I'm happy that we managed to finish quite in time. Thanks for your support, and I think you deserve an applause as well. Nice and so interactive, but I enjoyed it a lot. And I wish you all safe travels back home today, a nice evening, safe travels back home. And as it is not so far away, Merry Christmas and a Happy New Year. Looking forward to seeing you again. Keep up with the good work. Thank you very much. With this, I close the workshop.
One more for the chairman.
Thank you very much. Thank you, Mexico. Thanks to all of you. That's very kind. I appreciate it. The roundtable is closed. Have a good time.